moment I can see it, streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tuning every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey guys, I'm back. Okay, we are exploring court cases around the world. So today we're going to be in Iowa, and not sure if any of you guys are familiar with this case. It's Todd Mullis. He is the one that was convicted of murdering his wife because she was cheating, and so he supposedly murdered her with a rake. So, and his defense team had requested for a new trial, and it looks like they're going to get a new trial. But let's go ahead on and get a little bit of information. It starts at 10 o'clock, and I wanted to give you as much information as possible. So we're going to run through a couple of videos here and to help you guys get a little bit familiar with the actual case before it starts. So let me go ahead on and bring it to you guys. All right, this is what we're going to share right now. And let me go back a little bit, and here we go.
Delaware County 911, what's the address of your emergency? Hello?
I'm on the road. I'm out of breath.
Okay. What's going on, sir?
My wife, she's not responsive. I don't know if she tripped. I don't know. She was halfway out the door. I sent my son over to check on her. He yelled at me, and she looks gone.
Okay. We'll get an ambulance for in just a second.
I'm headed there. I grabbed her and I threw her in the truck when my son pulled me.
Okay, you're headed to the hospital, and she's in your vehicle?
Yes, and there's no pulse.
There's no pulse. Can you pull over?
I can.
Okay, how about you pull over?
Can I do anything? She's just, there's nothing.
Okay, what is your name, sir?
Todd Mullis. You feel anything? Amy.
Okay, sir, what happened that she's not conscious or breathing?
She fell on a fork. I took a goddamn fork out of her. It was an old fork sitting in somewhere, and then she was halfway out of the barn. Like, she was calling to get out, and then just yelled, and I ran over there, and she was laying there. She is not responding.
Okay.
Come on.
Sir, do you feel comfortable doing CPR?
I can try. I'll try anything.
Is she flat on the? Are you able to get her flat across maybe the seat?
Yeah, 1, 2. 1, 2.
Go on.
Come on.
Okay, that is the 911 call when he's calling 911 to act like he's trying to help her. But the autopsy from the coroner showed that it was homicide instead of her falling on or having an accident with the rake. Supposedly the rake was on her back. Hold on a second. I'm going to go bring up some more stuff in regard to this case. All right. I'm not going to be able to play the whole thing because it's going to start soon, but this is just going to be a little background of the whole case, okay? Just 1 second. A little background. And it's called Farmer Murdered Cheating Wife. To go, y'all. Oh my God, this music got to go. Oh, sorry about that, because I don't want to get dinged and they playing all this y'all. I'm sorry, but I'm trying not to get dinged, and they are playing music, and I don't know if this is copywritten music or not, but you guys can go and take a look at this for yourself. It's called Farmer Murders Cheating Wife with Corn, Rake, and Claims She Fell Killer's Case. That's what it's called. Okay. I'm trying to protect my stuff, so I don't want to keep playing it, and it's a copywritten type of music and stuff like that. So if you want to get some background story on this type of stuff, please go ahead on and take a look at this on your own. Okay. So let me stop this one here. We're going to go to the next one. So I was trying to show you some background, but I can't. All right, let's see if this one here, since it's not too much music on this next one here. Let's see if we can do this one. All right, let's see if we can do this one. All right, y'all. The music got to stop. Why can't we just get something without the music? Why can't we just get something without the music? It's ridiculous with this music here. But anyway, it's about to start in the next 19 minutes, and maybe we can have some conversation in regard to, let me see what I can find, what else I can find in regard to this case here. Because Lord have mercy, this music got to stop. Got to stop. Let's see. Trying to see a news article on it. Let's see. Let's see. This one is a little bit less music. Let's see if I can put this one in here for y'all. Hold on. A little bit less music. Let's see.
Some kind of freak accident. It's funny because, when you think of like a rake like that, you think of kind of like Looney Tunes, stepping up, boing. No, she had fallen on it.
What is your name, sir?
Todd Mullis. She fell on a fork. I had some goddamn fork on her. I don't know how that freaking happened. I'm sorry about my cursing.
Can you pull over? I've got an officer almost to where you're at. Sir, do you feel comfortable doing CPR?
I can try. I'll try anything.
Now.
Come on, respond. Come on.
And when they arrived, Amy Mullis was pronounced dead at the hospital in Manchester. It was only about 20 minutes from the Mullis farm. Upon pronouncing her dead, it was decided by the medical examiners that it was what happens all the time on farms when you're working with sharp instruments and big machinery. An accident. Until it was seen that Amy had 6 holes in her from a 4-pronged corn rake. So she obviously, fell a few times. After she was stabbed with a corn rake by someone, it was quickly ruled a homicide.
Oh, Lord, here comes the music. Lord have mercy.
Todd and Amy Mullis, in 2018, had been married for 14 years, got hitched in 2004. They were happily married for quite some time, had 3 kids together. Todd was working away in the farm. Amy was a nurse in the emergency department at Manchester Hospital, a hospital she would later pass away at. So, things were grand until 2013, when Amy had an affair. Todd discovered this, but they decided to work things out. They went to counselling together, but Todd, his trust was poo-pooed by this point, and he said, here, listen, do you want to make things work, make our marriage work, make the farm work, make, the life for our kids work, you're going to have to quit that job at hospital, come and work with me on the farm so I can
monitor you.
She better start shoveling shit with him because he was not going to let her out of her sight. Their trust was gone, and I guess he didn't want to lose her again. So that's, what they did to keep their farm, marriage, and 3 kids together. But I guess it was kind of like putting a plaster on a corn rake puncture. I really forced that one. Because in 2018, things were not looking so hot once again.
Oh my God.
As the investigation into the death of Amy Mullis began, obviously, the police started by speaking to the number 1 person of interest, the husband. And they wanted to know how their marriage was, 5 years after the wheels came off. And Todd was like, yeah, it's great. Or sorry, what he says is communication is good.
Describe you and Amy's relationship to me, Todd. How would you describe it in the last 5 years? How would you describe your marriage to me? Well, she's great. We were together all the time, and we were together.
Being deliberately political about how he's trying to word this. The investigators, however, already knew that was a lie, and that Amy had started having another affair. An affair with a farm manager named Jerry Fraser. He was the farm's bookkeeper, and him and Amy would talk all the time about work. And in May 2018, 6 months before Amy's death, it graduated into something more. In fact, it's believed that Amy was planning on leaving Todd, divorcing him, and taking half the farm with her. Amy would tell friends she felt like a prisoner in her own home, in her own marriage. Todd, she told friends, would manage everything. She essentially had an approved list of people she could see and be around, all vetted by our number 1 hog man. And it seemed that Todd, being, what we hear about him to be, had become suspicious of Amy once again. He had gone over her phone records and discovered she'd been sending a shitload of texts to Jerry Fraser, and he'd been sending quite a few back. Now then, Todd went to speak with Jerry's wife, because of course Jerry was married too. And she told Todd, everything's grand, don't get your knickers in a twist, he's She's not having an affair, don't worry about it. Their marriage was good, so Todd, I'm sure it's all good. All gravy. So that kind of relaxed Todd, a bit. But there was an affair going on. Jerry Fraser, by the way, was cleared relatively early, the other man in her life, and so on. He was out of town about 45 minutes away. His alibi was airtight, as was, his phone records and phone location. Didn't seem like anyone had snuck onto the farm and attacked Amy Mullis with a corn rake or anything. So Todd denied knowing about the affair. The police didn't buy that. So what actually happened on that day? Well, Todd and his son Tristan would often work together on the farm. That day, they were as they usually would. Amy was helping out, and the two younger children remained in the abode. So while they were all kind of working away at different bits and bobs, Tristan noticed that his mom, Amy, she was kind of dizzy. She was losing her balance quite a bit as she was tinkering with bits and yolks around the place. See, what happened was that 4 days earlier, on the 6th of November, Amy had an outpatient medical procedure, so she's a bit woozy. After a while, Todd told her to finish up and head inside. She's not well. But he asked her before she went if she could grab the pet carrier. He'd need it later, as they had kittens and he wanted to round them up before heavy machinery was roaming around, 9 lives won't stand much chance against that. So Todd and Tristan kept working away. Then, about an hour and a half later, they headed into the office. Todd and Tristan were together the entire time. Neither, like said the other, snuck away. Todd, looking out the window, saw the pet carrier wasn't where he asked Amy to leave it. So Todd was like, oh, fuck's sake. Tristan here. Tristan went into the red shed and found his mother, Amy. Todd raced in, took the rake out of her back, took it out of her back because he wasn't able to carry her out of where she was with the rake still in her. And then they started driving. So how did Amy have 6 holes in her from a 4-pronged rake? Well, the medical examiner would say she appeared to have been stabbed twice, perhaps even 3 times. There were also injuries to her face, hands, and knees. There was probably a struggle, or it could have been when she hit the ground after being impaled. There was blood on the ground, but no real evidence of a struggle, no markings or blood spatter anywhere else in the shed. Now, the fact that Amy was dizzy that day and had, a procedure just a few days prior seemed convenient to the police, in that, to them, Todd wanted to make it look like it would be an accident. He chose, after she'd had the medical procedure, to kill her. Well, they were very convinced he had killed her at this point. He wanted to cover, essentially. And another thing was that they had a security camera system on the Mullis farm. It worked the day before, it worked the day after, didn't work that day. Todd Mullis never admitted or cracked or anything during the hours of questioning.
We completed our investigation at this point, and the case very clearly shows that you're responsible for Amy's death at this point. I'm responsible. This Saturday was something of a combination of a perfect storm for you and Amy. There were a lot of things going on, not just in this in the months before, but in the months, years building up to this. There's a proceeding that transferred in 2009. I mean, no more time. We were so mad about that, and we felt betrayed again. The mystery's going on with some death. I mean, I'm just trying to kill him out. I'm so ready to kill him. And I can understand why. And it's hard to record it.
So they kept digging. Next, they undertook a search warrant of the Mullis property. They seized computers, electronics, iPads. And get this, on the iPad, they found searches for killing unfaithful women, killing cheating spouses, and what happened to cheating spouses in historic Aztec tribes. Spoiler alert, nothing good.
Delaware County investigators arrested a man today for the murder of his wife. Todd Mullis, who is 42 years old, is in the Delaware County jail tonight on a first-degree murder charge. Investigators say he killed Amy Mullis last November at their farm in Earlville. The Delaware County Sheriff's Office says Mullis stabbed her to death with a corn rake. Investigators originally said that she died in a farm accident at the couple's home. They ruled it a homicide less than a month later. Court documents show that Amy Mullis feared for years that her husband might kill her. Investigators believe that Todd killed her last fall because he believed she was cheating on him.
And so, with all that, in January 2019, Todd Mullis was arrested and charged with his wife's murder. The trial was on, a trial in which Todd himself would take the stand.
Todd Mullis, on or about the 10th day of November 2018, in Delaware County, state of Iowa, did kill Amy Mullis. The defendant has entered a plea of not guilty.
This brutal, senseless murder happened not far from here. He wasn't going to let Amy get away with cheating on him again. And more importantly, he wasn't going to let Amy take half of his farm. Amy was fearful of an affair. He would kill her. And she also told another friend that he would make her disappear.
To the prosecution, Todd was an angry, jealous, cold-blooded killer. Amy was scared of him, and she knew that if he learned of the affair, it'd be curtains for Amy.
He used a corn rake because he tried to make it look like a farm accident. He was hoping that people would just feel sorry for him and not ask any questions.
So his explanation was the only one he could think of. This wasn't something he manufactured. It was like, what else could it be? She was dizzy in the hog barn. Here we find her with this fork in her back. She was trying to get this pet carrier out of the shed. I don't have any other explanation.
To the defense, Todd was a hard-working, salt-of-the-earth man. They tried to point the finger elsewhere, but never really at anybody definitively.
Todd Mullis' statements about Amy falling on a fork and dying accidentally was a honest, legitimate, on-the-spot explanation or an attempt to explain what happened to her. It was wrong. She was murdered. Horribly. But I believe that you will find that not only at the end of this case that there's a reasonable doubt about Mr. Mullis' guilt, but there's no doubt at all.
Also, the defense attorney really looks like he doesn't want to be there, doesn't give a shit. Jerry Fraser also took the stand and did say how Amy was afraid of Todd.
Did she tell you how Todd treated her?
She made different notes, or not notes, but said she felt like a slave or a hostage. One time she did say that if he ever found out, she would disappear.
Were you afraid about Todd finding out about your affair?
Yes.
Why?
Oh, why wouldn't you be?
Tristan, too, the only witness, was called up. He was called up on video.
My mom, she kind of, she said she was getting dizzy, and she said that she was bleeding because she had had a surgery a few days prior to that day.
How long were you and your dad in the hog barn together after your mom left?
Probably about another hour and 30 minutes.
A few days before the trial, Tristan revised his statement. He said Todd was out of his sight, didn't know how long though.
At some point, did you lose sight of your dad?
Yes.
Do you know exactly how long your dad wasn't in your sight?
No.
The time that you didn't see your dad you obviously didn't see your mother either.
Yes.
You did not see your mom at that time? Sorry,
yes.
That was confusing.
Yes.
No, you still, as you sit here today, can't think of any person that would want to do this to your wife.
No.
Any person that would know that she was in the red shed at that exact time. You can't think of any person. Can you?
Right now or then?
Then, could you think of anybody?
I couldn't think of anybody then.
Like you said, some of those Google searches were yours.
Yes.
But sometimes Amy would use your iPad.
She would use the iPad, yes.
Okay. Amy would physically use that iPad, right?
Yes.
Like to search things, obviously, yesterday, like that wedding stuff and bride stuff. I mean, like you said, you didn't do that, right?
No, I did not.
Pinterest, none of that stuff. January 5th, 2018, there's a search for characteristics of cheating women. Did you do that search?
No.
Okay. Do you know who did that search?
No.
You have no idea.
No.
There's a search on here that same date, 16 facts about cheating women. Did you do that search?
No.
So the 911 call comes up again, and during that call, Todd pulled over to do chest compressions. Tristan got out of the car to flag down an ambulance. So this part is kind of reminiscent of the Mark Duenas case. You remember that 911 call in that one when it's like, did he say this? Did he say that? This is that.
When they asked me to do CPR, I said I'll do whatever will help her.
And you mean that? You'll do anything at that point to help save your wife.
Yes.
And you start those chest compressions, right?
Yes.
And you heard that tape when we played it the other day, right?
Yes.
And at that point, what are you thinking when you're doing that?
Trying to get her to come back.
You're just trying to save her.
Yes.
Right? Now, Todd, here I'm gonna play you the part where you're doing the chest compressions, and I'm just gonna ask that you listen in between the chest compressions, okay? Now, Todd, did you just hear that whisper at the end of that?
Yes.
And what did you whisper?
I couldn't hear it.
Okay, I'm gonna play it again. Todd, do you whisper cheating whore right there?
No.
So you don't remember what you whispered?
No.
Okay, I'm gonna play another clip for you. Do you know what you whispered there?
No.
Did you hear that? Right there, do you say go to hell, cheating whore?
No.
This, to me, is not nearly as clear-cut as the Mark Duenas one. It's so muffled and the quality is so bad I don't really buy it, is what I'm saying. But when someone, quote, tells you what he's saying, you're like, oh yeah, he is saying that. Yeah. I'll leave that for you guys to decide. But let me tell you what the jury decided. That Todd Mullis was guilty.
2941. We, the jury, find the defendant, Todd Michael Mullis, guilty of the crime of murder in the first degree, signed by the jury foreperson. Is the defendant.
He was sentenced to life in prison.
I did not do this. This is supposed to be America where you have a fair chance of proving your innocence. We shouldn't have to prove your innocence. Instead of the other way around, I thought it was guilty until, or innocent until proven guilty. I feel this is the other way around. And I was a faithful and loving husband, and I never did this.
All right, so now go ahead. It's about to start. The hearing is about to start in a minute. So we will. It hasn't started yet. But I know there's a couple of things that's going on right now. We have McBurney, who's doing a second hearing for the young man who was given a new trial. Well, they're trying to see whether or not he's going to get a new trial. We have that. And we also have our Louisiana border pardon. We can watch that later on. So you guys tell me what you want to do, because we're still waiting for this case to start. It hasn't started yet. Yeah, this one hasn't started yet. I just wanted to give you guys a little bit background of that particular case. And see, I know I shouldn't have never put the name of the person in. I should have just kept it as exploring around the world, but I'll just add on plus. You know what? Let's go ahead on and take a look at McBurney's case. Okay, let's do McBurney.
The screen as well. There. Okay.
Thank you. I would ask the record to reflect that at our last hearing, there was a discussion about the Clinton County transcripts. I indicated that I would email those to Mr. Armstrong, and I did email the transcripts that I had received from the family to Mr. Armstrong after that hearing. 3 days ago, Mr. Armstrong emailed to me the Clayton County transcripts that he had received from Clayton County. And I also noted that there was a file where he had entered those as exhibits. I guess then my first question is, he been offering those as exhibits? Is that the reason for that? I mean, yes.
So you want to ask Mr. Armstrong a question, not me. I did see a little bit of email traffic. Ms. Hansberry forwarded to me. The way I understood it, Mr. Armstrong was able to get the entire transcript. His concern at our last hearing.
Okay, that's boring right now. That's boring. They're talking about transcripts and all that kind of stuff. Because you need a transcript whenever you're doing a new trial. That's part of the process of them getting all the information so they can make a real educated, knowledge-driven decision on whether or not to get a new trial. And usually the transcript gives you everything that happened in that particular proceeding of the trial. So that's why they're asking for a transcript. And every single appeal, any kind of request for a new trial, any habeas corpus, anything like that requires them to go and look what the trial judge did and what happened in the trial. And that transcript usually have to be up to par, and as far as the information has to be accurate. So, because they utilize that a lot. Okay, let's see what else we can go ahead and check out. Okay, they start now. They start Mullins. Okay, here we go. All right, we start Mullins, y'all. At least we started this one on time, right? Welcome, everybody. Please make sure you hit the like button while you're in here. Share this live. Let us know. Get into the algorithm, since we're one of the ones that's showing this case. If anything we don't do in here, we're going to learn something about the justice system. We're going to learn all different aspects of it. And this is in Iowa, y'all. I'll make this a little bit smaller right now because it's too much noise. Isn't it a lot of noise, y'all? I'm going to turn them down a little bit. I'm going to turn down all that noise because it's like we have a lot of like air noises type of thing, like air conditioners going on and stuff like that. It takes them a little while to get started, huh? 10 o'clock becomes 10:30 for some of these people, man. Oh, they muted it. Thank God. Woo, Lord Jesus. All right, y'all. They're still trying to get this up together to start the trial hearing. I hate to be sitting here doing nothing because I could be doing other things while I'm just trying to wait so I can put the volume back up because I turned the volume down. Maybe now that they have it all quiet, maybe I can go ahead and turn it up. And maybe I could turn my volume back up so you guys can hear, since they got it turned down in there. Good morning, everybody that's coming into the chat. Hope you guys are having a wonderful morning. As you guys know, this week you have oh, I got some 411 for some people. Oh, I got some stuff update for my R. Kelly fans. The one somebody had put out that I got some 411 for y'all. I got some 411. Got some 411 for you guys. I know somebody put out yesterday that he was out. He's definitely not out. He's definitely not out, but I gotta tell you what's up. I gotta tell you what's up, because y'all, I always try to search and get the 411. I'll search and get the 411 for y'all, because I got what the ability to network with others to get information out for y'all, so information will be accurate and not flimsy, whimsy information. So, my R. Kelly fans, I got some 411 for y'all. In regarding to that pardon. Stay tuned. I knew you were going to pop out with the eyes. We got to talk. We got to talk, y'all. Writers, we're going to have a real meeting. We're going to have a real meeting on how to bring this information out to the folks. You know what? I'm going to have a members only meeting. A members only for those who wants to know. Yeah, we're going to have a members meeting this afternoon to give you guys an update on R. Kelly's pardon parole thing. I got the information on that. I told you I was going to find the answer and stop with the nonsense with the people with the fake news. You already know how I stand, what I. And if I get the information wrong, I will always come back and let you guys say, hey, what I said was incorrect. My accountability partners, guess what? Today is the day I take my shot. Oh, I just pray that today will be not a bad day. I won't feel any nausea. We're praying that no nausea for me today. No nausea for me today, y'all. No nausea for me today. We believe in God. There's no nausea. You say it must be something good. What must be something good, Tress? What must be something good? Come on, take it off of mute now. Y'all can put it up now. Come on. We want to hear what y'all saying up in that courtroom. We don't want to be sitting here with no noise and people just listening to me. Folks want to hear what's going on in the courtroom. You better not today. I better what? Not today. What do you mean, Serena? Come in. What's up, Miss Dally Dow? You on break?
Yeah.
Kobe, you've been good, huh? You all happy? Your mama gave you some good food, so you a happy camper. Bringing bones in here. I don't want a bone.
I just hid it from you. It was fit.
Where your bone? Where you going with the bone? You was looking for one of these.
I had to buy one.
I gotta go lay down. You gonna lay down for 15 minutes? Oh, another R. Kelly? You said another R. Kelly? Another R. Kelly? What do you mean by another R. Kelly? There's more than one R. Kelly? You said another R. Kelly. Oh my God, these people are taking so long with this court thing. Come on now. Oh, me, yeah. Not today, Serena. Not today with that nausea crap, right? Not today. Not today. We're not dealing with that today. Oh my God, y'all, they taking too long. You said, Pop? Thank you. Can we move on? Do we mean to people? Patience, my dear. Patience, Mimi. And you know, I'm a very patient person. You can tell by the time I sit in the courtroom all day long, I'm a very, very patient person. Certain things I say I'm not patient. That's because I choose not to wait on certain things. But when we deal with the court system, I'm very, very patient. It gives you guys time to talk with each other while we sit here and wait. Ah, Jesus, 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 Jesus. Build a fence all around me. I got some stuff to do. I need to gather some stuff in regard to my case. Guys, I go back to court on April 4th and 7th for my case. Just in case you guys wanted to know, I go back to court on April 4th and April 7th. Hopefully, with this last round, I'll be... And hopefully after this last round, I won't have to deal with the court system other than me going to cover other people's trial. I've been working on some things and trying to get different things, getting this channel back going, you know. One thing about, you know, what I'm going to do a little class on some of the high and lows of being a content creator, on having channels, and you know what, do's and don'ts, what I've learned as a content creator doing trial vlogging. That's a pretty good topic to talk about. We're gonna do that. We're gonna do that. We're gonna do that. They said experience is the best teacher in life. When you go through something, you experience it. That's how you learn. And even with the failures, it's still a learning curve with failures. All right, I think they get ready to get started now, y'all. I think everybody's up in there. They're getting started. That's Law and Crime guy with the little antenna. It's the camera guy. Is that a man or a woman right there? Oh, that's a woman. The short hair one, that's a woman, right? Oh, he's putting the mic on her. The guy in the blue is putting the mic on her so they could be able to hear. Okay. Mods, we're gonna have a mod meeting because some things I've been seeing that's been being put in the chat, it's not acceptable for me as mods. And so we're gonna have to have a meeting. Moderation is to moderate the room. We're gonna have to have a training. You know what? I'm gonna find because one of the things that the lead attorney was talking about that one of the mods that she knows how to do moderation, and I think we need to learn. And I'm going to cut down the amount of mods that I do have as well. He looks slimmer. Jail food must not be doing good for him. They get to wear t-shirts over there in his jail? He got an orange t-shirt on. He looks totally different from the guy that he was bigger back then. Hopefully they'll get started real soon.
Good morning. We'll go ahead and go on the record in Delaware, PCCB 009057. Todd Michael Mullis versus the state of Iowa. Mr. Mullis appears in person this morning together with his counsel. I believe the first thing that we need to address is the applicant's motion in limine. There are, I believe, 4 points. Is there any resistance on behalf of the state?
Good morning, Your Honor. I'm just taking a look through it again just to make sure, but I don't believe we have any resistance on that, and we would join the motions as well. Obviously, any undisclosed testimony from their experts, hearsay, things of that nature, we would agree that the rules of evidence and civil procedure control on that.
Thank you, Mr. Bakke. The applicant's motion in limine then will be granted in its entirety. Counsel for the applicant, did you desire any further record on that motion for any reason?
No, Your Honor. Ms. Erica Nichols-Cook on behalf of Mr. Mullis today, for ease of the court reporter, we don't need an additional record.
All right, thank you, Ms. Nichols-Cook. Any other preliminary matters then that counsel wishes to address? Ms. Nichols-Cook?
Your Honor, we briefly talked off record about some exhibits. I'm still talking to the state about that, and we will update the court on the next break. And I think we would request to do a short opening statement, but we don't have anything else preliminary.
Any preliminary matters that the state wishes to address?
No, Your Honor, I would agree with that recitation of our understanding.
Okay, Ms. Nichols-Cook or one of your co-counsel, if you're ready to proceed with your opening, you may do so.
Yes, Your Honor, Ms. Thompson is going to do the opening.
Ms. Thompson, whenever you're ready.
Your Honor, with the court's permission, I'll stand just for this opening portion of the proceedings today.
Certainly.
Good morning, Your Honor. Todd Mullis has always believed that his wife, Amy Mullis's death was a tragic accident. He always believed this because he was on his family farm the day that she was injured. He was there right after his son, Tristan, found her. He was there as he and his son, Tristan, tried to give Miss Mullis emergency aid and rushed her to where EMTs could get her to the hospital. He was there when first responders treated her injuries like they were the result of an accident. And he was not aware of any information that would tell him that what happened to her was anything other than an accident. Even when police began an investigation and began to treat him like a suspect, he did not stop believing that what happened to Miss Mullis was an accident. He knew he had nothing to do with her death, and he didn't believe that there was any evidence that anyone else did either. His account of what happened and his beliefs, unlike the accounts of some of the people that you're going to hear in this post-conviction trial during this week, has always been the same. But at trial, he did not have any way to present evidence to the jury that this was an accident. And that issue is what the court's going to hear about over the course of this hearing. The court's going to hear evidence that he begged his attorneys, begged them all through pretrial preparation to investigate this case as an accident. The court's going to hear evidence that his lawyers disregarded what he was telling them. The court's going to hear evidence that his lawyers did not talk to experts or fact witnesses that would have helped them understand and present a case that this was an accident. And the court's going to hear evidence that his lawyers did not listen to his explicit direction to investigate these issues and to pursue this case as an accident. And because his attorneys did not listen to him, because his attorneys did not investigate or present these issues, the jury did not hear important evidence that they needed to hear to understand that the state's case was simply wrong. The jury heard the exact opposite of what Todd Mullis asked his lawyers to present. They heard his own lawyer in opening statements tell the jury that Todd didn't know what he was talking about, that Ms. Mullis was murdered. They heard his own lawyer, in effect, tell the jury that Mr. Mullis was not credible. They heard his own lawyer make these concessions on day one, right when this trial began, and then really have no defense to present on Todd's behalf. His lawyers conceded guilt in this case without any plan to present another defense. The court is going to hear evidence that Todd didn't agree to this plan. He didn't know this was the plan. He'd actually asked his attorneys to do the opposite. And at this point in the proceedings, the court has heard in various pleadings at other hearings that we've had, the PCR team for Todd repeat this to you over and over again in all of the filings, that this was an accident, that this is what this case is about. And we've repeated that to the court because it's true. And it's among just the many reasons that Todd Mullis deserves a new trial and what this court is going to hear at this hearing. On behalf of Mr. Mullis and his team, we're grateful that after all this time that we're here, that Mr. Mullis is able to be in court this morning to remedy this wrong. Nobody listened to Todd at trial, but this week he'll have an opportunity to be heard through this case. And the court is going to hear other important evidence as well that the jury never heard, that is going to create at least the reasonable probability that the outcome of his trial would have been different if the jury had heard everything that the court is going to hear over the course of this trial. The court also knows that this is the rare PCR case here in Iowa with an actual innocence claim. And that is what the court is going to believe and know about Todd after this hearing. The court also knows that all of Mr. Mullis's most important claims survived the summary judgment rulings that the court made, and that the court is going to hear his claims and his evidence this week. And everything that this court is going to hear is going to establish that the underlying trial that Todd had was nothing short of fundamentally unfair. It was unfair because of the actions that his trial counsel failed to take, that any reasonable attorney would have done on Todd's behalf. It was unfair because the state withheld from Todd important favorable evidence that would have undermined confidence in the outcome of this trial. And it was unfair because the trial prosecutors did things that resulted in misconduct in how they presented the case and what they presented. And the court's going to hear evidence that makes clear that Todd Mullis was right. As we said, the court will hear that Todd's attorneys conceded right at the beginning of this trial that this was a murder. And with that sort of tentpole in the state's case, the state killing the jury and nobody disagreeing that Ms. Mullis was murdered, that resulted in a situation where there was really no meaningful adversarial testing of any of the evidence that the state presented. And the court's going to hear evidence about each of these issues this week. The court is going to hear that the state then was allowed to present witnesses giving contradicted hearsay and innuendo that painted Todd in a bad light. The court's going to hear that that evidence painted a false image of Todd, of his marriage to Ms. Mullis and his family, and that made random Google searches that were done by a family with a house full of teens and preteens seem like evidence that Todd was planning to harm his wife. The court's going to hear the truth about those searches this week. Without Dr. Cruz, the state's main witness, telling the jury that this was a murder, that evidence is what it is, which is kind of silly, meaningless, evidence that really doesn't explain to anyone what happened to Ms. Mullis. The court's also going to hear from fact witnesses that have important details that help us understand what experts that the court is going to hear from this week are going to say, which is that Ms. Mullis's death was an accident. The court will hear from first responders and from other people through depositions and through live testimony who witnessed medical efforts for Ms. Mullis. The court's going to hear from those experts that I mentioned that are going to explain from a variety of disciplines how all of the objective evidence in this case demonstrates that Ms. Mullis's death was an accident and that the testimony that Dr. Cruz told the jury in this case was just wrong. The court is going to hear, either live or through depositions, from Todd Mullis's trial counsel. And the court is going to learn about the mistakes that they made, and that those mistakes were not about strategy. They were just mistakes, things that were just wrong and cannot be explained by any strategy. The court's going to hear from an expert, Sean Castle, who's going to explain that the family's Google search history and electronic data from their home is exactly what it appears to be. Google searches from a family, from teens, from preteens that are using Google to search for things, sometimes random things, as we would all expect teens to do. And the court is also going to hear from depositions, from documentary evidence that makes clear that anything that anyone testified to about at trial about Todd is going to be a product of them being told that their friend was murdered. And believing their friend to be murdered, made statements that were hearsay, that were innuendo, that don't aid in understanding what happened to Ms. Mullis at all. I want to say one final thing about the evidence that the court is going to hear during this trial. Mr. Mullis is here today because the state made the Mullis's private family tragedy public. And I say this because Mr. Mullis is here, his children are here, members of his family are here, and certainly for Todd and his family, they would have preferred that the investigation into Ms. Mullis's case was private, and that their family's privacy was respected, and Ms. Mullis's privacy was respected. If that had happened and the authorities had made the right decisions in their investigation, then he would not have needed a public hearing like the one today to get the justice that he would deserve. And it is truly unfair to Mr. Mullis, to his children who are sitting here today in support of Todd and his innocence, to have this be the forum to discuss the issues in this case. And I say that because the court, over the course of this week, is going to hear scientific evidence that is going to be difficult for this court to think about and to hear and to see. And as Todd's attorneys, and on Todd's behalf, we're going to do the best we can in our presentation to respect Ms. Mullis's privacy, to respect the tragedy of her death, but it's going to be difficult to do that in light of the evidence that we need to present, because Ms. Mullis's private medical information is going to be the subject of this hearing, her privacy in terms of her body, her privacy in terms of the detail of her death and her medical history. Those are going to be made public during this hearing. Her private life. Everyone has things that are appropriately private about their life that shouldn't be the subject of a public hearing, but we're going to have to present and hear about some of those things this week, and present them in a public way that Ms. Mullis and the Mullis family don't deserve. This is not how Mr. Mullis would choose to have this resolved. But that said, because this is the evidence that the state relied on to charge him, because it's the evidence that was wrong, that was relied on to convict him, because his lawyer was ineffective in combating all of this evidence, all of the errors at trial that led to us to be here today, this public venue is the only way that Todd can achieve justice. And that's why he'll be presenting about these issues this week, because he does deserve a fair trial, a trial where the jury hears the truth about what happened, a truth that's grounded in science and that's grounded in what knowledgeable, experienced professionals have to say about what happened to Amy Mullis and what those knowledgeable professional experts concluded about the facts of this case. That's what this trial is going to be about, Your Honor. And at the end of this hearing, the court is going to agree that Todd's trial was undeniably unfair. If the state chooses to retry Todd after this hearing for what science tells us, and will tell this court was simply not a homicide, then a jury deserves to hear the truth at a fair trial where everything is going to come out from knowledgeable, experienced people that will allow the jury to know the truth. And at the end of this hearing, Your Honor, the only just outcome will be to grant Todd Mullis a new trial. Thank you.
Thank you, Ms. Thompson. Counsel for the state, did you have an opening you wish to present?
Briefly, Your Honor. Thank you.
Whenever you're ready, Mr. Duden.
Thank you. Good morning. My name is Josh Duden, along with Thomas Bakke and Scott Brown. I represent the state of Iowa in this post-conviction relief proceeding. As the court knows, Todd Mullis was convicted in September of 2019 for first-degree murder by a unanimous jury for causing the death of his wife, Amy Mullis. The Iowa Court of Appeals affirmed that conviction later on direct appeal. And here we are in a post-conviction relief proceeding, which Mr. Mullis has brought and commenced to attack his conviction again. The evidence will show, and the evidence has in fact already shown, that Mr. Mullis took the stand at the underlying trial and agreed that Amy Mullis was murdered. He agreed on cross-examination that somebody took a corn rake and stabbed Amy Mullis in the back 2 or 3 times. He agreed on cross-examination that he actually knew this wasn't an accident. And yet we are here today to ensure justice and a fair trial occurred. The evidence will show that sufficient evidence still exists to support the murder conviction of Todd Mullis' murder conviction. The evidence was enough for the Court of Appeals to affirm it, and the evidence will be enough for the court to deny this post-conviction relief application in its entirety. Many, many claims are brought pending before the court right now, but the important evidence was presented at trial. And a shrapnel shot approach, or a shot in the dark, in a way, is not a way to hit the mark here. The evidence will show certainly that expert testimony will not be enough to attack what the evidence actually showed at trial and what has already been upheld on appeal. And that's that Todd Mullis murdered his wife, Amy Mullis. And so at the end of this, the state will ask the court to deny his post-conviction relief application and let his conviction stand to ensure that a just trial had occurred already, and find that his conviction of first-degree murder should stand. Thank you.
Thank you, counsel. Are you ready to call your first witness?
Yes, Your Honor. The applicant will call Carrie Pierce-Cochran. Your Honor, is the court's preference that exhibits be put on the screen for everybody and the witness to see?
We can do it that way if you have them on your computer.
We do.
Okay.
I know, I feel like you also have to allow or hit a special button. So.
I do. Let's see if we can get that rolling. Go ahead and have a seat. Ms. Pierce-Becker, if you want to pull that screen up in front of you just a little bit, because that's where the exhibits will display for you.
Okay, thank you.
Okay. Can you see the attorney? Yeah,
I can.
Okay, and you can adjust that so that
Okay.
it's not blocking you entirely.
Okay, thank you.
All right, and I'll swear you in.
Okay.
All right, you've been called as a witness. If you'd raise your hand, you've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
Yes.
All right, Ms. Nichols-Cook, whenever you're ready, and just for your benefit, when you identify an exhibit, it will be displayed on my screen and the witness's screen initially. Once it's been admitted, then we can put it up on the big screen, assuming I initiate contact with all the right buttons. All right.
Thank you, Your Honor.
Okay, whenever you're ready.
Ms. Pierce-Bacher, could you state your name for the record today and spell it for the court reporter?
Yes, my name is Carrie Pierce-Bacher, K-A-R-I-P-I-E-R-S-C-H-B-A-C-H-E-R.
Thank you. We appreciate you being here today. Can you tell the court how you are employed?
I'm employed by Edgewood-Colesburg School District in Edgewood, Iowa as a music teacher. I'm currently the 512 band director is my current position.
And do you also volunteer in your community?
Yes, I do. I'm a volunteer fireman and EMT in Greeley and an EMT in Edgewood.
And Greeley and Edgewood would both be towns or their own municipalities?
Yes, they are two separate towns here in Delaware County. They're closely located together, so and I work in Edgewood, so we kind of run with both services, and both services do work closely together. So a lot of our calls are shared. If one gets called, a lot of times the other one will as well. Not always, but often.
And both Greeley and Edgewood, are they entirely volunteer organizations? And does Greeley run at the EMT level or at a different level?
We run at an EMT level. That means that we're guaranteed to have at least one EMT on the rig when the ambulance leaves and arrives at a patient.
What can an EMT do?
An EMT does basic life-saving support. We can do CPR, we can splint, we can do basic life-saving care. We cannot do anything invasive, such as in IV, and we cannot administer any drugs through IV or through injection. We can give basic drugs such as oxygen, aspirin, Narcan for a suspected drug overdose, and we can give albuterol for a breathing difficulty or an asthma attack.
Okay.
And those are the 4 drugs that we carry in Greeley that we are allowed to give.
What's the next higher level of care?
After EMT, then you would get to the paramedic level, and they can do those extra things. They can start IVs, they can administer drugs, and that would be the next level up. Edgewood runs at a paramedic level, and then I believe Manchester is a paramedic level, and then Colesburg and Earlville, I believe, are provisional Ps, which means that they sometimes have a paramedic on board, sometimes don't, depending on the availability of their paramedic in town.
And would you consider all of these agencies to be emergency responders or first responders?
Yes.
And how long have you been an EMT?
Getting close to 25 years now. I think it was 2000, 2001, around in there is when I took my classes and completed them. I believe I started them in fall of 2000 and completed them in 2001.
And you mentioned that you had to take a class.
Yes.
What are the components of that class?
The class, I don't remember the exact hour amount, but there's so many hours of class time instruction. It lasted 5 or 6 months when I took the class. It began in late September, early October, and ran through March. We met 2 to 3 nights a week for 3 to 4 hours a night. Sorry. Yeah. So we 2 to 3 nights a week. And then, so that was the classroom portion. And then as we were taking the classes, you had to pass the different units within the class. Once you passed the class, then you had to also do ride time and clinical time, so many hours working at a hospital ER, making patient contacts and practicing your skills there. And then also so many hours ride time, which would be with an ambulance service, again, making patient contacts and practicing in ambulance situations. Then once that was all done, then you were finally qualified to take the state test where you had to pass skills tests. And then if those were passed, then you went on to take the written test. And then if that's what was passed, you got your license.
Perfect. And then you could start.
And then you can start, yep.
And do you also like recertify or have continuing education?
Yes, we have to do the certifications just changed recently. Now the current level is it's 20 hours of recertification every 2 years for an EMT, but there are certain categories that have to be met. You have to do certain hours of cardiac, airway, trauma, etc. It used to be, it was just a blanket 24 hours of recertification, any topic. Now they have different topic categories that you have to hit in order to recertify.
Great. And for the paramedic services like Manchester, are they also volunteer or are they employed or full-time employees?
Most of the services in Delaware County are volunteer, except Manchester is a paid service. They are run out of the hospital, and that is their job is to be on call in the ER and run with the ambulance.
And so as a volunteer, if you're not on a schedule or you're not being paid for certain hours, how are you notified when your assistance is needed?
We all carry pagers or radios. Greeley actually carries like radios similar to a walkie-talkie, that if it's set on page, you only get notified when your department is paged, or you can possibly open it up if you want to and listen to everything that's going on in the county, and then you would hear when other towns are getting paged as well. But then when that goes off, then we know that we have a call and we respond to the station.
And you also live here in Delaware County?
I do live in Delaware County.
And did you grow up here?
I did grow up in Delaware County as well.
And so are you familiar then with the geographic area and the roads and where different landmarks are?
Yes,
I want to ask you specifically about a call that, and about November 10th, 2018.
Okay.
Judge, can we approach for a quick moment?
All right, y'all, they're doing approach to the judge's bench. My apologies. Hello, everybody that's coming in here. That's in here. Let me say hello. Nadi, let me say hello. I gotta say hello to everyone. Hold on, sorry. Hey, pretty chick. Hey, tall glass. Hey, CMT. Hey, VK. Hey, Tracy B. Hey, Marge C. Hey, Bless. Hey, Felicia P. I can always depend on Felicia being in here, right, Felicia? Felicia with her wonderful questions. Hey, Naughty Lynn. Hey, I'm Miss New Orleans. Hey, Nosy Rosie. Hey, Bless. Hey, Classy Coco. Hey, Tracy. I'm trying to say hello. Hey, BK. Hey, Seth. Hey, Tracy. Hey, Mimi. Hey, Tall Glass. Hey.
I've just been informed that there are individuals observing the trial who are taking photographs with their phones. That is not permissible. Any phone in the courtroom is to be turned off and put away. If photography, videoing, or anything is observed by any non-approved individual, there are obviously members of the media who have been approved, but any other individual who is taking photos or recordings of any sort,
Wait a minute.
if that is observed or it continues, you'll be asked to leave the courtroom. Thank you.
They went and told on y'all. Tad, they tried to tell on y'all.
Yep, you may continue, Ms. Nichols-Cook. Ms. Pierschbacher,
I wonder if it's the
you're
same person
very
that told on me
fast.
telling on the people there.
Slow down.
And I
apologize.
don't blame you. Nobody wants to be the first witness.
Yeah.
So if you can slow down just a little bit.
I will try.
Okay, thank you. All right.
Yeah, Tad to
Ms.
tell.
Pierschbacher, I believe we were getting ready to start talking about November 10th, 2018.
Yes.
Do you remember that day and what you were doing?
Yes. That morning, my husband and I had gone to Cedar Falls to pick up our 3 kids. They had a sleepover with their grandparents the night before. And then as we were coming back from Cedar Falls and traveling north on Highway 38, just about home, my husband did have his pager open. As I'd said, you could just listening to traffic, and we heard a call from Manchester Ambulance to the Earlville area for what appeared to be a farming accident at that time.
And so when you say he had his pager open, are you saying that it was open to the entire Delaware County
Yes,
traffic?
we could hear everything coming across. It's called County Fire. It's the channel that all the fire and EMS are paged on. We didn't necessarily hear what all law enforcement was saying or what anyone else in the county. It was the fire and the EMS paging channel is what he had open.
And you were with your husband, Dave?
Yes, Dave, my husband.
Same last name?
Same last name, yes. David Pierschbacher was his name.
Can you tell me a little bit about Dave and why he had a pager?
He was the fire chief in Greeley. He ran basically the fire side of our service. And at the time I was the EMS officer, which put me in charge of the EMS side of our service, but it was basically one combined service. So yes, we were both members of Greeley Fire and Ambulance. We both carry pagers. His happened to be open to the Delaware County channel at that point in time. Mine was closed to just page.
And do EMTs normally work together in twos or in pairs?
Our protocols is that you always go with at least two. You never leave the station without two. And since we are an EMT service, one of those two must be an EMT. We do have members of our service who are fire only. We have some people who are EMRs, which means emergency medical responders, which would be the next level below an EMT. There's a couple of skills that EMTs do that EMRs cannot. And we have a few of those, but our protocols are if the ambulance goes, there's a minimum of two people on board, and one of those two must be an EMT.
And was Dave an EMT?
He was as well, yes.
And it's my understanding he's unable to be here today.
No, he is not here today.
And why is that?
He passed away in 2022.
Okay. So while you were driving back from Cedar Falls, I think you started to say you were listening to traffic and you heard a call. Can you tell us about that call?
We heard, it sounded like Manchester ambulance getting paged for what at that time appeared to be a farming accident. It said that there was a male subject who was transporting a female subject to the hospital along 170th Street, that she had been hit by forks, and that that Manchester was paged out to intercept with them. But also at some point it was said that the original location was somewhere near Earlville, because I remember Dave asked me, why is Manchester responding to Earlville? And I said, I don't know.
Was that unusual?
Not kind of. Usually Earlville would have taken that area, but we didn't know, were they out on another call or something else? There are circumstances where different ambulances cover different territories.
And is Earlville also a volunteer?
They're also volunteer.
EMS? Okay. And did you have any impression or recollection of what the demeanor was while you were listening to this radio traffic from dispatch?
I just remember everything just seemed very confusing. We were just listening to the traffic and we heard Manchester ambulance go en route, and we heard them continue to ask dispatch for a location, and that they said that they were coming in on 170th Street. And then at some point we heard them say that the subject had stopped so that they could start CPR on the female victim, that they were somewhere along the road on 170th Street. So Manchester ambulance headed in that direction. And so we were still continuing north on Highway 38 from Delaware to Greeley. And at some point, Manchester ambulance was continuing to ask for more directions, or how far out are they? And they really weren't getting any information. And then Manchester ambulance asked dispatch to page first responders. And that's when Dave and I said, oh, that's us. We need to get to the station, because we even flipped on our blue light, our light that we use to respond to situations. And we started heading right for the station, thinking that it was us getting paged and we had to get there. And then dispatch actually paged Manchester first responders. So we're like, oh, but we were already at the station at that point. So we just waited for a minute to see what would happen.
And for those of us that didn't grow up in Delaware County, how close is Manchester and Greeley, or along 170th Street?
Along 170th Street. 170th Street, it's also known as the Oneida Blacktop. It is a long road, I don't know, probably 12 miles, I'd say, between Greeley and Manchester-ish. I know it's 17 to my house, but I live a little bit further than Greeley, so.
At some point, while you and Dave were at the Greeley station, did you prepare to respond or leave the station?
At some point when we continued to hear the voice traffic back and forth of where are they located, how far out, Dave did get on the radio and ask Manchester ambulance if he would like Greeley to respond from that side of 170th to see if we could find them, and figuring between Manchester and us coming from the two directions, eventually we would run into them at some point. And Manchester ambulance responded yes. So Dave and I got in the ambulance and took off, and we radioed to Manchester that we were en route. We radioed to Manchester dispatch that we were en route.
Okay. And so is it a fair characterization that the people needing help were somewhere on 170th Street? The Manchester ambulance left from the hospital in Manchester, and then you left from Greeley.
Went from Greeley.
And you guys, did you eventually meet?
At some point we were going to meet up. We actually found the victim first. They ended up being very close to Greeley. Actually, they had not gotten as far as close to Manchester as we had thought they had maybe gotten. We actually found them just south of Greeley, 2.5 miles at kind of the intersection of 38 and 170th.
Great. What did you see when you got to that intersection?
When we got to the intersection, the first thing we noticed is the flashing lights from the deputies' cars. At that point, the deputies had arrived. We had just passed that location a few minutes before, but didn't notice anything. Now we saw the flashing lights, and so we're like, that's where it is, and we radioed to Manchester where we were. We went to turn into the driveway, and one deputy ran to the road to meet us to make sure that we saw them and that we knew that's where we were going. So we pulled into the driveway. It was a driveway of a home that was under construction at the time. So there was nobody who lived there. And the driveway was very rocky and muddy. It was under construction. And so when we pulled in, we could see a deputy was performing chest compressions on the female victim. And there was a forklift nearby for the construction of the home. And so after being paged that we had heard somebody hit by forks, I was still thinking bale spears from a tractor. And then I started to think, oh, that forklift was somehow involved in this incident. And so Dave and I pulled the ambulance over as we pulled into the driveway to the left to get out of the way for the other approaching ambulances. I went directly to the victim to relieve the deputy who was giving compressions, and Dave got the equipment out of the ambulance, the Lucas device and the AED.
Okay.
And then he met me at the victim a few seconds later.
And if I missed this, did you know who was building that house or whose property you were on?
I did know whose property we were on. It's the property of Brian and Rachel Krogman.
And you mentioned that from the radio traffic and from the dispatch statements that you thought you were going to a tractor baling fork accident.
That's what I thought.
For those of us that aren't farmers, a baling fork, a larger item?
It's a large attachment that goes on the front of a tractor to move large round bales.
And did you have any concerns about a patient being transported by their family towards the hospital?
No.
And why is that?
Because it's common in our area. We're very rural. We all know what the transport times are and what the response times are. I know just for our own department, our goal is from the time of the page to be at the patient within 10 minutes. And I think the community knows that too. So, and I know a lot of people kind of think, well, I can be at the hospital in 10 minutes. And so, no, it is not unusual for a family member to just take a loved one on their own, thinking that they could probably get there faster than waiting.
And in your 25 years of being an EMT, have you responded to other farming type of accidents?
Yes. It's not uncommon in the area. It happens. It's a farming community.
Okay. Circling back to what you saw when you were in the driveway, can you describe the patient and what you did next?
As I approached the patient was lying on her back. One of the deputies was doing chest compressions. I observed she was wearing, it appeared to be heavy chore type clothes, like a thick Carhartt coat. Underneath was a thick hooded sweatshirt. I believe I said she was lying on her back on the gravel driveway. Her head was turned slightly to the right, and her face, the right side, was covered with blood and a brown substance that appeared to be vomit. And the vomit was coming from her nose and her mouth. It was on the right side of her face, and it was also caked in her hair.
Okay. And what was the first thing you did when you reached the patient?
I took over compressions for the deputy.
Why did you do that first?
Because 2 minutes is about the limit that anyone can do good chest compressions. It's just standard that you try to relieve a compressor within 2 minutes if possible, just because after that fatigue starts to set in and then the compressions aren't always as effective. I had no idea how long he had been doing compressions. I was guessing probably longer than 2 minutes at that point. So I was trying to relieve him and get a fresh person on her until we could get the other equipment in place.
And when you started chest compressions, were you doing them over the sweatshirt or over the coat?
The coat was open, but I continued to do compressions over the sweatshirt.
And did you observe any other obvious injuries or wounds?
No, not at that time.
And were you expecting to see something else?
Well, I was picturing getting hit by bale forks. I was expecting to see very large wounds somewhere and that I was not seeing. And so I was confused as to how the bale forks came into this picture, because I wasn't seeing the massive trauma that I was expecting to see that I would expect bale forks to cause.
And did you know who the deputies were at the scene?
One was Deputy Thompson and one was Deputy Holub.
Okay. Did you guys have a conversation or exchange information about what had happened?
We just started talking. I do know at one point when I started compressions and I asked what happened, one of the deputies told me, I think we were dealing with a fall. And then I'm pretty sure at one point I asked, did this happen here? Because I was still under the impression that that forklift I saw sitting off to the side had somehow been involved in this incident. And then that's when Todd, who was in the background, he said, no, this didn't happen here. This happened at our farm a few miles east of here.
Did you know the identity of your patient at the time?
At that point, no, I did not.
Did anybody else from the Greeley EMT team respond?
Eventually, there was a third Greeley person who got to the scene of the patient, Steve Engelken. As I took over compressions, I did ask the deputy to page Greeley for more help, because at that point, our pagers had not tripped yet. It was just Dave and I. I knew we had other people close by that we could probably get there faster, even the Manchester ambulance could, if they would just be paged. And the deputy asked for Greeley to be paged, and the dispatch replied with, Greeley's already on scene, they don't need to be paged. And so we asked again to have them paged for more help, and then Greeley was paged. By the time most of the responders responded, Manchester had already gotten there. So Steve Engelken is another member of our service who did get to the patient. I believe he got there at roughly the same time that Manchester ambulance arrived.
Okay.
But I know he was helping with resuscitation efforts at some point. The rest of the Greeley people arrived, but already saw Manchester ambulance and Greeley ambulance and everyone there. So they stayed on the road and conducted traffic control and did not approach the scene.
Okay. And then you mentioned that Dave got the Lucas device and the AED off the ambulance. Can you tell us a little bit about what a Lucas device is?
A Lucas device is basically an automatic CPR device. There's a board that resembles, I don't know, maybe a snowboard would be the closest comparison I can think of. Has a slight curve to it. It goes under the patient's back, like from armpit to armpit. And then there's another U-shaped device that comes down and clips over top of that. And then from that device, there's a plunger that goes down onto the patient's chest. And then once it's turned on, the plunger does the compressions for you. So then the manual compressions are no longer an issue, and we don't have to worry about rescue or fatigue. The Lucas just keeps going with good quality compressions.
Okay. And so, and then how is an AED different?
The AED is an automatic external defibrillator. That is the part that actually attaches to the person's chest and shocks the heart to try to get it back into rhythm.
Okay. And what did you do? What did you guys do first?
Once Dave got to us with both of those devices, the first thing we did is attach the AED. At that point, we pulled the victim's sweatshirt up and we attached the two pads. The pads go upper right, lower, and then on the right side, and then on the rib, lower rib on the left side. So we attached the pads, we turned it on, it analyzed, and then an AED is looking for a certain cardiac rhythm before it will issue a shock. So as it analyzed, we stopped our compressions and let it analyze, which is protocol. And then the first time it analyzed, it said no shock advised, which meant it did not pick up that shockable rhythm. Continue CPR, so we continued CPR.
Okay. And when you pushed your patient's clothing up, did you make any observations about other injuries?
Yeah, as we lifted up her shirt, we were looking for some other things to see, because I was still trying to figure out how this injury happened. There was what appeared to be possibly a slight bruise on the right rib cage. At that point, it was very faint. We thought maybe it was a bruise, but we weren't 100% sure. And then there was also a mark above her right breast that looked possibly like a very small puncture wound. But again, we weren't 100% sure what we were looking at. We saw something there, but we saw something, but had not, were not able to determine what had caused that. So we made note of it in our report.
Did you observe anything, any injuries on her face area?
Again, possibly a slight bruise on the right side that was noted in the report. Again, at the time that we saw her, it appeared very faint. We thought it was possibly a bruise, but we were not 100% sure. So again, we noted it in the report.
After you set up the AED, did you then do the Lucas device?
Yes, once we did the first analyzing with the AED and says no shock advised, continue CPR. I continued manual chest compressions, and then Dave and the deputy started setting up the Lucas device. Dave started and the deputy assisted with getting everything in place. I continued manual compressions until the Lucas was in place and could start.
Okay. And you were able to utilize the Lucas to do chest compressions?
Yes, and then once it was in place, we turned it on and the Lucas took over chest compressions.
What did you do after that?
Then I went back to the ambulance to get the airway bag to secure an airway and to start breathing for the patient. So I brought the airway bag back to the patient, opened it up. I took out a King LT. That was the intubation device preferred at the time. And so that's what I took out. At the time that I had gotten that out, then that's when Manchester arrived on scene.
Okay.
I apologize for the interruption, but could we have a quick sidebar?
Sure.
Uh-oh. What happened now? Somebody tattletale again? Somebody tattletale again? What do you think happened, y'all?
Again, folks, I want to be crystal clear that unless you are an approved member of the media, there is to be no photography, recording, social media posting, or
social media?
any recording of any kind
What are they doing over there?
of this proceeding.
Didn't I tell you?
I am aware that there is a specific individual in this courtroom who has posted photos on a social media site from this trial this morning. It is only because I cannot ascertain specifically if that photo or those photos were posted before or after my preliminary warning that individual is not already being removed from the courtroom by a deputy. If there are any further posts, the individual will be removed, as will any others. We will not have this proceeding derailed by members of the public who are not following the restrictions on recording, photography, and the rules of this court.
Y'all know it ain't me. I ain't in the courtroom.
My apologies to the witness and to counsel.
Sign on my thing. It ain't me.
I hope we have no further interruptions. Ms. Pierschbacher, again, if you can try to slow down. I think you just get faster and faster. Okay. All right. Ms. Nichols-Cook, whenever you're ready.
Thank you, Your Honor. Ms. Pierschbacher, maybe act like we're high schoolers, I guess, and we don't listen the first time and just go slow for us. But we were talking about an airway bag.
If it's the girl in the
And
brown back there.
could you help us all understand a little bit about what
I think it's that boy with the plaid.
What you were using? I think we've all seen mouth to mouth.
I would love to
and
know.
so
what
tell me
page
about the
they
airway
posted it on,
bag.
so we can go watch
Okay,
it.
so our airway bag specifically carries all of the equipment that we would need if a patient were to have a breathing problem. There is an oxygen tank in that airway bag. There is also it's called an AMVU bag. It's the bag that you put over their mouth and squeeze to help ventilate them, that we carry in there. There is also nasopharyngeal airways, which go into the patient's nose, and oral airways, which are hard airways that go into the patient's mouth that are used to hold the tongue out of the way. Those airways are used for a patient who is still semi-conscious and would have a gag reflex, who would not tolerate anything down their throat. In this particular case, we used a King LT, which is a long tube that is inserted into the patient's mouth, and it goes into their trachea, and there are two balloons that blow up to hold it into place. And then there's a small opening at the top that AMVU bag I was talking about. If you take the mouthpiece off, the round tip goes right onto the top of the King airway, and then we can ventilate directly into the patient's lungs. So that is what I was getting, the airway bag, and that's what we had decided was our best option for that patient at that time.
Okay. And was your patient responsive at all?
No.
And in order to insert the tube then into your patient, did you have to do anything with her mouth or her nose?
Yes. So when I inserted the tube, what I did is I positioned myself at her head so that she was directly in front of me. I was at the top of her head. Other people were still working on doing things with her. I was kneeling on the ground above her head. And then what I do to insert is I reach through and I grab her lower jaw and her tongue, and I lift it up to pull the tongue out of the way and to open her mouth. And then with my other hand, I take the tube and insert it into her airway. And then we have a syringe that then blows up those balloons to hold that tube into place.
Okay. Earlier, you mentioned that the right side of your patient's face had blood or maybe a vomit substance.
Yes.
Was that still present when you were inserting the tube?
It was still present. And before the tube was inserted, we used a suction device to suction her mouth clean and clear so that we could get the tube in without getting any extra debris into her airway.
Would getting debris in her airway be harmful to your efforts to get her breathing?
Well, it could, because then it would be basically like aspirating whatever that was, and then it would just cause further problems for the patient down the road.
And I think you mentioned that as you were working to do this, the Manchester paramedics arrived.
Yes, the Manchester crew arrived because at first when they arrived, we filled them in on the situation and told them what we had done so far and what we knew. And then I actually backed off on the airway for a moment just because at that time it was their scene to control. And I just said, we're about to insert an airway. And then that's when they said, well, you are an EMT, you can do that skill, right? And I said, yes, I can. And then they said, please do help us. And so we stayed on scene and continued to help them as they were doing what they were doing.
And in addition to suctioning out the mouth or and the nose, did you also have to move her face or handle or wipe things off of her?
I don't remember if we did any wiping. I do know we did have to suction, and then her head was turned slightly to the right, so we would have pulled her head back to center to make it easier to insert that tube.
Okay. After you inserted the airway tube, what do you remember doing next?
At that point, then we hooked up the airway bag, and I started to ventilate for her. The ventilations were going in harder than I expected them to. I was feeling some resistance, which is not normal. But at that time, that's when we were getting ready to move the patient. They had brought a sheet from one of the ambulances. And so the way that we lifted her that day is we did something called a log roll, where we roll the patient onto her side, put the sheet under her, pull it back out from the other side, and now she's laying on a sheet instead of on the bare ground. And then we're able to use that sheet to lift her and get her onto the cot and into the ambulance. So the sheet was the method that we used that day to get her up onto the cot and loaded. So at the time I got the airway in place was the time that we rolled her, got her onto the sheet, and moved her towards the ambulance. I was ventilating the whole way to the ambulance. When we got to the ambulance, I did tell the paramedic, please check this airway. There's more resistance than there should be. Make sure I got it right. And then I handed the airway bag off to one of the Manchester personnel, and they continued care to Manchester.
Did you note any other injuries during that log roll procedure?
During the log roll procedure, I did not see any other injuries myself. As the patient was rolled, I moved with her face to continue to give ventilations. I did hear one of the Manchester responders say, we have a through and through, when they saw her back. I personally never saw her back at the scene. I don't know what it looked like, but I did hear one of the Manchester responders make that comment.
Did you note any other injuries to her mouth, a cut or anything like that?
No.
And in your experience, is the act of performing CPR or using a Lucas device a traumatic event to the body?
It can be, yes.
Was your care ending then as the patient was loaded into Manchester's ambulance?
Yes, that is where our care of the patient ended. We handed off to Manchester. Shortly after Manchester ambulance arrived on scene, so did Manchester first responders, because they were paged out after. So between those two crews, they got enough people in the back of the ambulance to continue care all the way to Manchester. So it was Manchester's full ambulance crew. And then I believe a couple of their first responders who came out in the first responder rig also went back with them to be extra hands to help with resuscitation. So we were not needed to go in the ambulance with them. They had enough people.
Okay. And at that And at some point, do you learn the patient's name?
Yes, as we were loading her into the ambulance, one of the Manchester responders or ambulance members said, "We need a name and a birth date for the victim." And then that's when we asked, "What is her name and birth date?" And that's when we learned it was Amy Mullis. Up until that point, I didn't realize who we were working on.
Had you met Amy Mullis before November 10th, 2018?
Yeah, we were acquaintances. Amy's and Todd's daughter was in gymnastics with my daughter, so we would see each other at gymnastics events, and they also attended the same church as us.
Did you realize the individual providing information to you during your care was Todd Mullis?
I did not realize that either at the time. It was out of context. I was used to seeing him together with the family, and this was out of context. So no, I did not place that. That was Todd as well.
Can you describe Todd's demeanor while you were on the scene?
From what I observed, he seemed to be kind of anxious, nervous. He seemed to be pacing in the background. He wasn't interfering with resuscitation efforts at all, but he was close by to provide information as we would need it. As if we would start to talk about something or ask something, he would respond right away with information he had or knew. But yeah, he was close by enough to give information, was pacing.
Nothing that alarmed you?
No.
Did, I'm sorry, let's start over. Did you also then know Todd and Amy's children?
I did. At that point in time, I knew the younger two children better. Wyatt and Taylor went to church with us. I was their Sunday school teacher for a while. I knew Tristan also at that point from seeing him in church with the family, but I did not know him as well as I knew the younger two.
Did you see Tristan on November 10th, 2018?
Yes, a little bit later. Up until that point, I had not noticed him. After Amy was loaded into the ambulance and Manchester took off for the hospital, we turned to start getting our stuff picked up, and that's when I realized Tristan was there as well. He was standing back a lot further than Todd. There was a trailer attached to the pickup that they had been using to try to get Amy to the hospital, and he was on the back side of the trailer.
After the Manchester ambulance left, what did you and the other Greeley EMTs do?
Because some of the Manchester first responders had left in the ambulance service or in the Manchester ambulance, that left a couple of their first responder vehicles unmanned. So our other responder, Steve, who was on scene, he actually helped Manchester to get the rest of their vehicles back to their station. Dave and I took the ambulance and we followed to Manchester because our Lucas device was still being used in resuscitation efforts. And so we said we would just follow and wait for it to be done to get it back. So we proceeded to Manchester. We stopped at the fire station we stopped at Manchester Fire Station to pick our other responder, Steve, up because that's where they keep their first responder vehicles after he helped them drop those off. And then the three of us proceeded to the hospital to wait for the Lucas.
Okay. When you got to the hospital, where did you go?
We just went into the common area in the ER, the hallways. We were just planning to hang out in a corner and try to stay out of the way until things were done.
And did you observe Todd Mullis or any of the other family there as well?
Todd, I believe, was there and had a friend with him. And they were in kind of the family waiting room. They had a special waiting room, not the general public waiting room that everyone goes into. There's a separate one back in the ER for family to wait in. And so he was in there with a friend.
Okay. Did medical staff approach you and Dave or Steve?
One of the RNs came up to us as soon as we got there and
what did you and Dave do after you interacted with medical staff?
We waited. Dave we would take turns waiting in the family room with Todd. Dave spent most of the time in there. I went in, I believe, once for a couple of minutes.
And were you asked to go in? Were you instructed or informed that you needed to go into the waiting room?
Objection, also hearsay relies on hearsay testimony.
No, not hearsay.
Your Honor, it's been offered to show what she did and why she did it.
Not hearsay.
Overruled.
Thank you,
The witness can answer.
We were told to make sure Todd was not left alone and to make sure one of us was with him at all times.
Hearsay again, ask that the objection precede the response, Your Honor.
Rule. The answer will remain in the record.
Overruled.
In your 20 plus years of experience as an EMT, has that ever happened to you before?
No.
Did you make any observations of Todd's demeanor while you were in the waiting room or at the hospital?
It was similar to on scene. He appeared anxious to me, was pacing.
At some point, were you able to not stay in the family waiting room any longer?
Another RN came in.
Are you familiar with former Sheriff LeClaire?
I am.
Did you see him at the hospital on November 10th?
I did.
Did you speak with him or see him speak to anybody?
I did not.
Response again, Your Honor.
I didn't ask what was said, Your Honor.
I did not speak to him myself. I did observe he and Dave speaking to each other.
And since Dave was a fire chief in the county, was that unusual or alarming?
No.
At some point, were you able to retrieve your equipment and depart Manchester Hospital?
Yes. At some point when the Lucas device was finished being used, we got it back and then we left and returned to Greeley's fire station.
Did you respond to any other EMS calls that day?
We did have another EMS call later that night.
Did that take you back to the Regional Medical Center in Manchester?
Yes, we transported that patient there as well.
Did you ever learn that there was concerns or instructions to complete your report in a certain way?
When we returned back for that second EMS call that night, we were actually with Edgewood crew at that time. Edgewood was the transporting service. They needed extra help. So Dave and I both ended up being in the back with the patient on the way in. When we got to the hospital, I stayed in the rig and started cleaning everything up. Dave and the rest of the Edgewood crew members actually delivered the patient into the ER. When Dave returned to the ambulance after dropping the patient off, he told me that—
Objection, Your Honor, hearsay within hearsay.
Sustained.
Let me try to rephrase a little bit there. Did you complete a report about the service call regarding Amy Mullis?
I did.
And did your husband, Dave Piersbacher, contribute to that report?
He did.
Did your fellow, or your colleague, Steve Ingleton, also contribute?
He did.
Okay. And did you have an understanding that you need to take some extra care or caution when writing your report?
Yeah, most reports are completed thoroughly, though I usually I always make a point that every report is completed thoroughly.
And at some point, did you learn that Amy's death was being investigated as a murder?
I did.
And do you recall when you learned that?
That evening at the ER.
I've got a copy of your report here marked as Exhibit 216. If we can show that to you to make sure we have the right report. We'll try to get it on the screen there for you. Ms. Clark, have you had an opportunity to look at Exhibit 216?
Yes.
And does this appear to be the report that you wrote and submitted regarding?
It appears to be.
And can you tell the date that you submitted this report?
I'm not sure it's on this front page, but if I remember correctly, it was November 13th.
And so that would have been just a couple of days after
Yes.
you responded to the call? And I think you just said you submitted it. Can you tell us a little bit about what that means? Like, how do you submit it? Where does it go?
The system that we use for EMS reporting is called Image Trend. We all go in and it's what every EMS service uses. We complete the report and then it stays open. And when we are satisfied that it is done, we hit lock and submit, and it is locked and submitted, and then it uploads to the state database. And at that point, then it is considered submitted.
Okay. And after you submitted your report here in Exhibit 216, did law enforcement ever talk to you about your observations from November 10th or your report?
No.
Did anybody from the Delaware County Attorney's Office talk to you about it?
No.
And I apologize, I said law enforcement earlier, specifically Delaware County Sheriff. Did anyone talk to you? The Iowa DCI?
No.
And have you ever spoken to anybody from the Iowa Attorney General's office about the substance of your report?
No.
And were you aware, or are you aware now, that Todd Mullis was charged with Amy's murder and tried and convicted of that?
Yes, I am aware of that.
And then we'll flip to Exhibit 215 and have you identify that for us.
Yeah, this is an affidavit.
So 215 is an affidavit that you signed regarding November 10th.
Yes.
And my copy is a little faint, so maybe yours is a little better, but is it dated in 2023?
I believe so. I don't see the signature page on my screen, but I believe that's when it was.
We'll scroll for you.
Yes, 2023.
And prior to this affidavit in 2023, did you speak with any attorney representing Mr. Mullis?
No.
Any private investigators or anybody talk to you?
No.
Was there anything about Todd's behavior or demeanor on November 10th that was alarming to you or caused you concern?
No.
Your Honor, if I could have one moment, and then I think we already have an agreement to admit 215 and 216, but I would formally move to admit those exhibits.
Okay, y'all.
You just got one or two more. I apologize. Thank you for your patience. Ms. Piercebacher, while you were on the scene that day providing care and waiting at the hospital, did you ever observe any or hear anything that caused you to think that Ms. Mullis's injuries were not an accident?
No.
And I know you said earlier that it's not uncommon for there to be farming accidents. And so can you expand a little bit on that? Like what types of accidents you have responded to over the years?
Your Honor, I am going to object on the grounds of beyond the scope of the lay witness's testimony. She's not a certified expert, and it's her testimony as to other incidents are irrelevant for her insight and for purposes of this proceeding.
Sustained. Let me re-ask that. Have you responded personally as an EMT to other farming accidents?
Yes.
And have those included things like falls?
Yes.
And onto whether it's a farm implement or a fork or some other tool?
Objection, Your Honor. Again, this is irrelevant. It's both beyond the scope, not an expert, and simultaneously leading.
Your Honor, I'm asking for her personal experience. I'm not asking for an expert opinion.
Overruled.
Yes, we have been called to emergencies that involved farm implement, and we have been called to emergencies where people have fallen. We've been called to emergencies where people have been trapped. Yeah, there's several different types of farming emergencies that happen.
Okay. One last question is, do you have any recollection of the weather on November 10th? It's winter in Iowa, but other than that, do you have anything?
It was very cold. I remember it was very cold, very bitter. I believe there was like a skiff of snow on the ground at the time.
Okay. Nothing further from me, Your Honor.
Counsel, any objection to exhibits 216 and 215?
Your Honor, no objection to the inclusion of 216, but we would object to the inclusion of Exhibit 215. As it is hearsay, includes hearsay within hearsay as well, and is inadmissible. I believe it also predates the filing of this case and therefore was not made as a part of the record for any sort of consistency.
216 is admitted. Counsel, did you want to respond to the objections 215?
Yes, Your Honor. I think there might be some confusion. I guess it was my impression the state had already didn't have any objections to 215, but additionally, it's a part of the original post-conviction relief application filing in this matter. Ms. Piersbacher has identified it, and I can ask her some additional questions as far as, where the information comes from in it. But I do believe it's an admissible document that this court should consider.
Well, to the extent it was identified as an attachment, I guess, to the petition, it's there. The court will consider it in that fashion. Generally, I'm not going to admit affidavits, though, of witnesses who are here to testify. So 215 is not going to be admitted as a separate exhibit. Cross-examination.
Yes, Your Honor. Good morning, Ms. Kirschbacher.
Good morning.
At the time of Ms. Mullis's death, you had been an EMT or volunteer firefighter for about 20 years. Is that fair to say?
Just shy of that, yes.
And since then, obviously, you are still a volunteer.
Correct.
On the day in question, you were dispatched around 11 minutes after noon, right?
Yes.
And you arrived somewhere around 12:14, 3 minutes later.
Yes.
According to your report, which has now been admitted as Exhibit 216, you reached Ms. Mullis or Amy Mullis for an assessment at 12:15, right?
I believe if that's what it says in the report, then yes.
And the Lucas device that you explained earlier was placed a minute later.
Yes, if that's what it says.
And at that time, you left Ms. Mullis's body, ceased compressions, and went back to the ambulance, right?
I did, because compressions were being taken over by the Lucas device.
So you didn't visualize her during that period of time?
I did not.
And you didn't administer the AED shock at 12:17 either, did you?
whoever was running the AED did at that point. That's the time that it was shocked.
And I believe if we turn to directing your attention to what is page 4 of Exhibit 216, I believe it references that David Pierschbacher was the one who placed that AED shock, right?
That is possible. Yeah, I don't have that page in front of me, but if that's what it says, then that's what happened.
And 1 minute later, Manchester Ambulance took over the care of and administered the life-saving efforts for Miss Mullis, right?
Yes, once they arrived, yes.
So the entirety of your interaction spanned about 3 minutes.
Probably, yes.
And for the portion of those 3 minutes, you weren't actually with Miss Mullis the whole time, were you?
Not the entire time, no.
And according to your report, as has already been admitted, you didn't see the injuries in question, right?
I did not.
And you didn't observe the full extent of any puncture wounds, right?
I did not.
You don't document any direct references to Todd Mullis in your report, do you?
No.
You never once reference Tristan Mullis in your report, right?
Correct.
And you were familiar with them, as you mentioned, right?
Mhm.
Because your focus was actually on Amy Mullis and preventing her or administering life-saving care.
Correct.
So what we do know from your report is that you'd agree that she had bruising documented to her face.
Yes.
And you didn't actually note anything about her hands in question, correct?
No.
In fact, based upon your examination, you had no reason to check her hands, fair?
We did not.
So you can't say whether or not she had any injuries to her hands, right?
That is correct.
Nor could you say that she has any injuries to her legs or feet, right?
No. Those, that was removed by Manchester Ambulance. They cut the rest of her clothing off of her when they took over care. So that's why that is not in my report, because that was under their care.
So directing to your specific interactions with Amy Mullis on this day, you administered manual compressions.
I did.
And you placed the King airway device, right?
I did.
Tube. How long or how many tubes have you placed, would you say?
Over the years.
Can we get a little, I'm sorry, objection, a little foundation as to like a time period? Are you talking the entire 20 years or?
Sure. In a general sense, without holding you to any specific number, over your 20 years' time at that point, how many airway devices had you placed? How many tubes?
At that point, well, those were relatively new at the time. I mean, we haven't had those in the entire 20 years that I had been in EMT, but I placed a dozen.
So you were fairly experienced or aware of how to place them?
Yes.
And to be fair, those don't come into contact with a patient's lips or anything like that specifically, right?
No, mostly it's my hand that comes in contact with her face or her lips as I'm moving her face out of the way to put the tube in.
And in this instance, Manchester Ambulance is the one who was doing the suctioning, not you,
yes,
right?
Yes, that is correct.
So you weren't applying any force with an outside suction, right?
No.
And do you recall or have any reason to believe you caused an injury to her lips yourself?
No.
And generally, when you place a King airway tube specifically, do you cause injuries to the patients you place them or administer them to?
I have not heard of that.
And in your instance, that hasn't happened, right?
No, not that I'm aware of.
So you don't have any reason to believe that she would have caused any damage to Amy Mullis's face or mouth or otherwise, right?
No.
And you didn't ride with her to the hospital either, did you?
I did not.
So your care or interactions with Amy Mullis ended at 12:18 or so.
Yes. Whatever time she was loaded in the ambulance, that's when my interaction with her stopped.
And so your total interaction with Amy Mullis would have been 3 minutes, right?
Probably, yes.
In your report, you don't call it a farming accident, though, do you?
What did I reference it as? What did I put in my narrative?
I believe when you were dispatched, and you can correct me if I'm wrong, that, like you said earlier, you believe that a woman had been hit by forks, right?
Yes, that's what it was dispatched as.
You don't mention a forklift, though, do you?
No.
And you don't mention any bale spears, right?
Nope.
So overall, you had no reason to believe or any reason to look into the cause of Miss Mullis's injuries, did you?
just to ask what had happened, and again was told we weren't sure. We thought we were maybe dealing with a fall, was the answer that we got on scene.
Is it safe to say that the family members who are noted in your report, that would be Todd Mullis?
Yes, I believe I just referenced family members in general, correct?
Correct.
Yeah.
So in that sense, it would have been reported as an unknown incident to you, right?
Yes.
So it wasn't referenced as an accident by Mr. Mullis. Fair?
No.
I'm going to object at that point as asked and answered and beyond this witness's testimony.
Overruled. The answer will remain in the record.
That was you? Yes.
Sorry, could you please re-ask the question?
So Mr. Mullis had never referred to it as an accident or otherwise to you, right?
No, it was very confusing. We were trying to figure out what had happened. As you said, the 3 minutes that I was with her, we were trying to see if we could resuscitate her. So that was our primary cause. In my mind, I was running over what could have happened, but our primary focus was to get her back, get a heartbeat and breathing.
So your job wasn't to look into what caused the
No.
incident in question?
We asked the questions to help us figure out what we're dealing with. But in this case, it was very confusing. Nobody really knew. So we focused just on what we could see and took care of that.
So we've referenced your report extensively, which has now been admitted as Exhibit 216. Who do you submit that report to?
I believe it goes to the Iowa Department of Health.
So it doesn't go to any specific agency for inclusion, right?
No, it gets uploaded to the state.
And I believe you've previously referenced the National Emergency Medical Services Information System.
Mm-hmm.
Fair?
Yes.
Is that also called NIMSIS?
Yes.
And for NIMSIS, do you know who that goes to?
I do not.
So is it safe to say that you've never in your 25 years checked into where that goes, right?
No, I do know that when our service gets inspected every 3 years by the state, the Iowa Department of Public Health comes out and they do have access to all of those reports, and they have all of our information on when reports were filed and in what a timely manner, and that is checked into them. So I do know that at that point, the Iowa Department of Public Health Emergency Services Agency, who keeps track of the EMS services, they have those reports.
And so those reports don't actually go to anyone other than the state agency designated to receive them, right?
As far as I know.
And in that case, the NIMSIS program is actually administered at the federal level. Fair?
I believe so.
So that data is not being aggregated by, say, the hospital in Delaware County.
I don't know.
You have never provided the report specifically to a hospital in Delaware County, right?
Not that final report, no.
Did you provide any other version of a report to a healthcare provider in this case?
Yes.
And so that would be documented in the medical records or referenced otherwise?
It should be in Manchester's report that they received ours. What we usually do is when we get on scene, we don't pull out our computers and do the final report there. We have handwritten notes and we pull off the top sheet and it goes with the patient. So in this case, when we handed off the patient to Manchester, our top sheet of notes went with Manchester to become part of their report.
And that's because it was Manchester who was in charge of her transport to the hospital.
Because they transported her, yes.
And in charge of handing over care to the hospital emergency room.
Correct.
So that wasn't you in this
We
case.
did not hand her over to the emergency room. No, we did not. We handed her over to Manchester Ambulance Service.
But on scene, you talked to Todd Mullis, correct?
Yes. Well, in passing, he was in the background giving answers. I did not specifically talk to him one-on-one.
You also confirmed some of the details with the deputies, yes?
Yes.
And so in question, you were also known to the Mullis family, weren't you?
I believe so. Somewhat more so Amy and the younger two kids at that point in time.
Because you went to the same church and your families interacted,
Yeah.
right?
Yes.
So at that point, Todd Mullis and you were already familiar.
In passing, as an acquaintance.
Ultimately, it's safe to say you can't actually explain the full extent of Amy Mullis's injuries that she sustained that day, right?
No, I cannot.
And you can't describe the extent of the location of where her injuries were seen.
No.
And your report would only document the injuries that would already be noted in her medical records or by other care staff, right?
Objection beyond the scope of this witness's knowledge. There's been no foundation laid that she's ever seen medical records from a hospital related to Ms. Mullis.
Kelly, can you read me the question? I'm sorry.
Your report would only document the injuries that would already be noted in the medical records or by other care staff. Right?
I'm not sure I understand the question.
I'm
Would you mind
happy to
repeating
rephrase,
one?
Your Honor.
Right, thank you.
You mentioned earlier that the extent of the injuries would have gone to Manchester ambulance, right?
Correct.
And that Manchester ambulance would have provided that information also to the hospital, correct?
Yes, they should have. Yes, I assume they did.
And that's because they ultimately transferred care to the emergency room, right?
Correct.
So the bruising on Amy Mullis's face or the puncture wounds to her body or any other documented injuries would primarily be noted by her medical records or by that staff. Is that fair?
Possibly.
Because you would have provided or noted the same injuries that were noted by Manchester ambulance, right?
No, objection, Your Honor. I think the question is asking this witness to say what Manchester paramedics did or what's in the Manchester reports, which she has not seen or nor did she write. So this is an improper question and asks for speculation.
Sustained.
After you responded for those three and provided those 3 minutes or so of care, did you have any other interaction with Amy Mullis?
No.
You did not provide the report to any law enforcement, correct?
No.
And you normally would not provide those reports to law enforcement,
Not
right?
unless asked.
I don't have anything further, Your Honor.
Any redirect?
Very briefly, Your Honor. Ms. Pierce-Bacher, law enforcement knew you were on the scene.
Correct.
You have been a member of the Delaware County community your entire life.
Correct.
Law enforcement spoke with you while you were providing care.
Yes.
Is it a normal protocol and or is it required by the Department of Public Health that you complete and submit a report?
Yes.
Do you have any obligation to send that report out to the law enforcement you interacted with?
No.
And you mentioned that you would have taken the top sheet of your notes and sent them with the patient. When you describe that, are you describing like a carbon copy where you also kept a copy of those notes? And we talked a little bit earlier about you submitted this report, but it included observations and actions of the other two EMTs from Greeley.
Yes.
Okay. And is that normal protocol for an EMS EMT report?
Yes.
And you were asked about your entire interaction with Ms. Mullis only being about 3 minutes. Is that unusual?
No.
You were asked a little bit about the dispatch and the farming records. And I believe you testified, and so I just want to clarify that you heard over your pager, over the radio, and dispatch was calling it a tractor, baling, fork type of accident.
Yes.
Okay. And you and Dave responded from Greeley in part because Manchester was not responding fast enough or could not find the patient. Is that your understanding?
Yes, there was confusion on where exactly the patient was located and how long it would take Manchester to reach them.
Ms. Pierce-Bacher, you heard us talk a little bit about your affidavit. Is there anything in your affidavit that you feel it is not accurate or reflective of your experience on November 10th?
No.
Objection relevance, Your Honor. This affidavit's already been excluded.
The objection's overruled. The answer will remain in the record.
Did you ever talk to anybody from the state medical examiner's office about Amy Mullis's death?
No.
Nothing further, Your Honor.
Any recross?
None needed, Your Honor.
Thank you. You may step down.
Thank you.
Let's go ahead and take a morning recess for about 15 minutes. I'll see you back then.
Well, let's see what's going on. Let's see if McBurney's cases have made a decision. Hold on a second, y'all. I am going to move over to McBurney and see what McBurney is doing on his case for new trial. I don't know if it's over with yet. Hello, everybody that's spending some time with me. Hello, 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 hello. I think McBurney's might be over. Judge McBurney. Oh, his is still going. Hold on. Hold on there.
Transcripts. Did you ever discuss this with Detective Martin?
I've had no knowledge of what you're talking about, so I could not have discussed it with Detective Martin.
Did it ever come up in any conversations with him?
Not that I have any memory of, no.
Did Mr. Shard ever talk to you about this?
Not that I recall, no.
If what I have told you is true, would you still try to introduce those statements by Mr. Singleton?
If what is true?
Promises, the threats, the physical force.
You're asking.
Would you still have tried as an ADA to introduce Leslie's statement at the trial?
So you're asking me if I believe your defendant that he was coerced into making a statement, would I try to introduce it? Well, no, not if I believed your defendant, but I don't think he said any of those things when he testified at the Fulton trial. Your client testified at his own trial.
The next question was Shard ineffective for not bringing out what happened through Leslie's testimony or attempting in any way to attack the officer's credibility?
Objection. She's asking the witness for a legal conclusion.
Right, you need to phrase it a little bit differently, that
Okay.
someone else will make the decision about ineffectiveness.
If a defense attorney did all that, would you as a prosecutor feel concerned, raise some type of objection?
If he did what?
She's getting a little antsy, y'all.
Let me ask that
Look at her arms folded in front of her. Little antsy lady.
If a defense attorney would have brought out.
Can I ask y'all something? Why is this
May not be admissible.
the Fulton County have seems like everybody has attitude.
But you had concerns about it, would you have done something about it?
That's such a vague question. I can't even possibly answer that.
That one I will do. What was your evidence of murder, hijacking, armed robbery against Stephen Morales?
Objection. The record will reflect what the evidence was.
I'm not so sure that it does. You got a first offender probation. There's no prelim, no grand jury, no trial.
What's the relevance here for Mr. Singleton's motion for new trial? What Ms. Ross thinks the evidence was against a co-defendant who didn't go to trial with Mr. Singleton?
One, it goes into why they didn't work out a deal with the shooter. Two, it goes into the lack of evidence against at least one of the co-defendants, i.e. without Waters, what evidence did they have against Mr. Singleton?
Your question wasn't about Waters, it was about the third defendant.
Yeah.
Okay. And I'm trying to understand the relevance of.
For one, it goes into the state bringing an indictment against somebody without any evidence other than he was somewhere in the back.
Okay, but let's assume Ms. Ross says, yeah, you know what, there was less evidence against him, that's why he got first defender. How does that advance Mr. Singleton's cause?
Well, my next question is, you say less evidence, what evidence did you have against Mr. Moritz?
Let's say the answer is we had none, which is why we pled it out that way.
Now I was going to ask, is there some similarities with regards to Mr. Singleton's case?
The guy sitting in the driver's seat of the murder victim's car who gets shot and his blood is inside the car, unlike the guy who got first offender probation.
I'm assuming your recitation is not your determining facts, not your normal testimony.
Is that not what the record was established at trial? They're two different things. What the jury heard and what the larger universe might show happened. But was it not the record made at trial that Mr. Singleton was inside the victim's car when he was shot?
That's what I read yesterday.
I appreciate you speaking for me, but if I can communicate instead.
Okay, that's enough. That's enough. But I need to make sure you're tethered to the record that was made at trial and not what you have heard from your client, because those are two different things. I'm not going to be able to rewrite the record that was made at the trial, but the record made at trial was that your client was in the car, his blood was in the car. Maybe I missed something from the trial record. But you know what, we don't even need to argue about that. You have not convinced me that it's relevant to ask this witness what was the state's case against the person who pled out who wasn't the shooter. I don't see the relevance. If you want to ask about Mr. Singleton, get there. Don't have all those other steps that aren't relevant.
This one here is spicy. This hearing for a new trial is spicy, y'all. Not like the other one, which was a little bit boring, but this one is spicy.
Not of proof of what the questions and answers that I was expecting was that it's only involved to be in there. You refused to testify against Mr.
Look at her arm. Her arm's folded like y'all not gonna get nothing from me.
When you return to his testimony, two, you have been a better witness than the shooter. Two, after you convicted Singleton, you gave arrest a plea bargain. Plea to the lesser offensive robbery, got first offender treatment, no adjudication of guilt, time served in 8 years on probation.
Angel, we can't help
The
you.
question
Sorry.
is, tell us whether the problems for the state's case against Mr. Perez is that likewise true, did not have a very good case against Mr. Singleton without Waters' testimony. Those are the questions I was going to ask.
Okay.
What can you tell the court about Michael Waters?
You need to narrow that question.
Look at her face. Look at her arm. Look at her face. Look at her demeanor.
I'm sure
y'all.
I did, but I have no independent memory of it.
Approximately how many times? More than once, more than 5?
I have no idea.
Lord, look
All
at
of the
her.
conversations recorded from the very beginning to the end, everything you or the officers said and everything that Waters said.
I don't know about Waters' statements to the police, especially because I wasn't there for those. But when I spoke with him, I don't know if it was recorded or not. I don't remember. Is it in the file?
It's
Okay.
like, I think it's investigator.
If it's in the file, it was recorded. If it's not, it wasn't.
I think she's an investigator. I think. Don't quote me. Now look at her arm. Look at her head tilted to the side. Look at her, y'all. She's like not having it with the defense. Not having it. She said, your client. Look at it. Look.
Did it help? I gave you a copy of that November 28, 2007.
Yes.
To her looking at a document? No.
You may, you have continuing authority to approach the witness. This is Mr. Waters' statement.
From November of 2000, November 28th.
Okay.
And this is a statement he gave to, okay.
So look at the first page, second paragraph.
I missed something about where the judge was going in on Armstrong. Armstrong is the prosecutor on the side. Him and
Where? First page, what,
Adam.
second paragraph? Off tape purposes, yes.
Some of his statement was taped.
Some of his statement was taped, and it also says that I talked to you earlier off tape to let you know the purpose of today's statement, but I want to start, if you could just go ahead and tell me your true, correct legal name for the tape.
Oh, so it was taped.
Sometimes
It was taped.
ADAs, police officers, first day, something was stated, and then they put it on tape.
No, what this is consistent with is I met the witness, and I don't go up to people because we didn't have body cam back then. So I didn't just walk around carrying a recording in my hand. So I introduced myself to the witness and then told him we were going to get a recorded statement. And then I recorded the statement.
You're talking to Mr. Waters prior to this statement.
I have no memory of that. I don't know. And if he's represented by counsel, I would never have spoken to him without his attorney, unless his attorney gave me permission to do that. But in this case, it looks like his attorney was present for this statement.
I remember multiple times getting him out of the jail, one time giving him McDonald's.
No, I have no memory of giving an inmate McDonald's.
Do you have no memory of giving an
You
inmate
agree that your
McDonald's?
questions on the November 28th statement were very limited.
She don't remember if she gave him McDonald's. Tyler, this is in Fulton. We're watching Iowa and Fulton. So they both doing cases.
I would say it's not the most thorough statement I have ever taken, but I am focused on the conspiracy between all three defendants in the robbery.
That the norm when you are taking a statement for purposes of a plea agreement?
It depends.
Go into details or ask what happened? Or want that person's testimony to be?
It depends on the circumstances. So in this particular case, he had already given a statement to the police. So I already knew what he had said there, which again, we discussed. He had two statements. One, he said CJ and Rod, and then the second statement the same night, he says he's the shooter and goes through it. So I had that, and then I guess this was a supplement.
That's what it sounds like, Angel.
Concerned that at least one of those earlier statements is not true.
I'm concerned. I had no reason to believe it wasn't true. Let's put it that way.
But there's two different statements, so one of them got to be a lie.
No, I thought the second statement was true.
See how you pick which one is true and which one is false.
That in this statement. So I'm trying to ask if I'm making prosecute, and there was a plea agreement with a person that actually killed this officer. I wanted to have a black and white right then and there. One of his attorney. This is what he's going to testify to at trial. This is what happened. You're saying that's.
I don't know what your question is. What's your question?
Oh, Lord.
Saying, as a former assistant prosecutor, I sat down with any co-defendant and their attorney, working out a plea agreement where that person was the person that actually shot and killed one of my police officers. When I took that statement for purposes of the plea, I would go into the details. This is what the testimony will be at trial, rather than hoping or assuming he will testify what I wanted to.
Well, I wanted to know what happened, and that's what I asked him.
He's going to say?
Well, I'm assuming he's going to say what he tells me here and what he had previously told the police. So yeah, I do.
First, second July 7th statement didn't matter. I'm just saying you are such a good prosecutor. I don't understand why you didn't go through the details as to what his expected testimony was going to be at trial. You're sitting with him, attorney
Oh, she's
present?
the prosecutor. She was a prosecutor at the time.
Objection,
Maybe I'm
Your
just
Honor.
not as good as a lawyer as you are. I don't know. I mean, I thought I had enough.
Whether she did something is a fact. What she would want to do in the hypothetical is not relevant and is not a fact.
Okay, I agree. Next question.
So she was a prosecutor at the time, y'all. That's why she has an attitude. It comes with the job, I guess.
Was Martin present during this interview?
So Daryl Martin was there, but that is my investigator from the DA's office. It doesn't, I started the interview by saying, and present here today is Michael Williams, along with his attorney, Mr. Mathis, Miss Williams, who I believe was an attorney also with Mr. Mathis. So he had two attorneys present, investigator Daryl Martin of the district attorney's office and me. So I do not believe
Yes,
that
we're in Fulton County, Tyler.
Detective Frank Martin was there, because if he was, I would have presumably said he was present.
What if he was in the room listening, watching TV? Testimony, is that possible?
I don't know where we were. Let me see if it says. We are at, I don't know, because we're at 185 Central Avenue, which is this building, in courtroom 7F. So I'm not sure where Detective Martin could have been if we were in the courtroom.
That would be not more, do something like this and not have your lead detective there?
It just depends. I would not agree with you that that is not norm.
Everything's normal in Fulton County.
Murders.
Yep.
Without having a lead detective present?
That's correct.
Wow. Really?
You or Detective Martin or anyone else talk to Mr. Waters that day prior to his statement?
I don't recall ever talking to Michael Waters until after he pled guilty. Until after he entered a plea of guilty.
This day.
Right. Well, this is the same day he pled, isn't it? Right. Okay. So this is,
How do you know it's before he, it may say so in the transcript. How is it you know that this conversation was before he pled rather than after?
Thank you, Judge.
So my assumption that you never enter a plea agreement with a murderer unless you had down what that murderer was going to say.
Judge, it also says she announces that it's 9:30 in the morning, which is typically when court begins in Fulton County.
This, the plea transcript says that, or?
The transcript that we're looking at, right? That
Got it, okay.
I believe Judge Downs started at 9.
Oh, never mind. I
If
stand
I
corrected.
recall.
Oops, you were wrong.
Also reference.
I don't want us to get wrapped around the axle on it. I just was curious if there was an indicator in the transcript saying, now that you've pled, or now that we've had this conversation, we'll go take your plea.
Anyways, reference to the arrest by motion, page 11, 2000-11-28, that would indicate the statement was given prior to this bond motion hearing.
Oh, so
Okay.
it's in there, page 11, he said. He thoroughly went over that transcript.
Looking at the November 28, 2000 statement, is it true that Waters never said it was Leslie Singleton who planned the robbery, provided the gloves and mask, that it was all Leslie's doing? I reference to where that was testified by him, 3B-695-696 at the Fulton County jury trial. Is it true that he never said that in this November 28, 2000 statement?
Hold on one second.
Your Honor, I would suggest that the document just be made part of the record, and whether something is not in there would be a matter for the record is the best evidence as far as having her testify to what's not in that transcript.
I agree. That makes it much easier. And then it's in there or it's not in there. Do you want to make this an exhibit if it is not already, Mr. Hort?
Trying to look back through my paperwork.
I know your exhibits went through at least O, but I think you added a few after that.
apologize, but my memory is that is an exhibit that I offered or asked to have introduced when we started today's hearing.
I do not recall that. I recall only marked exhibits, and I don't think this one has a mark.
F, B.
D, E, F, and then additional F, and then P.
Okay.
And also, there were some questions about J.
Yes. I had moved to admit into evidence defendant exhibit Y, Waters November 2000 statement received earlier from Mr. Armstrong.
Y, we're all the way up to the letter Y.
Sometimes it's easier to work backwards than try to remember what's.
Okay. I don't remember that being requested this morning, but let's admit defense Y, which is the November 2000 statement Mr. Waters gave to Ms. Ross and the other assembled individuals, not to include Detective Frank Martin.
Let's see it before I give it to you.
Oh, no, I found it in the exhibits that I gave you, or in the materials that I gave you.
Thank you, sir. So it's now in, and you're free to compare and contrast. We don't need to try to extract that from a witness saying it's something not present in an interview.
Why did you work out an agreement with the person who actually shot and murdered the police officer?
He wanted to enter a plea of guilty. And he expressed remorse for his actions. And he offered to plead to life plus 10. So
He offered, or was that offered to him?
he wanted to plea.
I realize that. My question is whether the life plus 10 was offered by you or the police or the state.
Well, it would never be offered by the police, so it would have come from the district attorney. And I don't know, because I don't remember specifically whether the defense attorney, I know I was surprised that he wanted to plea because we were in court and all of a sudden it was announced that he was going to plea. I don't know if the defense attorney came to me and said he'd take life plus 5, or if the defense attorney came to me, or plus 10, sorry, or if the defense attorney came to me and said he's interested in pleading, what can you offer him? But regardless,
You know that's what they said.
a desire
They said
to enter a plea of guilty and admit what he had done.
That ever come out from Detective Martin or otherwise that he was told that with this plea agreement he would do 10 years and be free?
No.
What about
y'all want to go back to Iowa? They back. Y'all want to go back to Iowa?
No, and that is inconsistent with the transcript of his plea that he took before Judge Downs.
Do y'all want to go back?
Put that in place in the transcript before Judge Downs that person was told he'd be home by age 31 and they could only do 10 years.
Well, I don't know why he wouldn't say that back to the judge when she's telling him what his sentence will be.
Well, you don't need to guess why it wasn't in there. If it wasn't in the transcript, it wasn't in the transcript of the plea.
Yeah, I'm just, as to why it wasn't in there, I'm refuting what she's saying.
But it doesn't matter why it wasn't in there. If it's not in there, it's not in there.
Did Detective Martin or anyone else tell you that Waters was told without the plea agreement he would die in prison?
I don't have any memory of that.
If anybody did tell Waters that with his plea he would do 10 years and be home by age 31.
Okay, I have to add this one to my title because you know
That would be inaccurate, but that is not what he was told on the record in the plea.
Sorry, I know you. I respect that you need to listen to the question.
She answered it. She said that would be inaccurate and that it was not presented in the record.
If anyone would have said that.
Fulton County, man, they just the attitude full of even the judge.
And she said that would have been inaccurate. If someone told Mr. Waters that would have been inaccurate.
Judge too. Oh, have mercy.
False, deceptive.
She used the word inaccurate to respond.
In addition, Your Honor, that's the law, and that's not dependent on what this witness testifies to.
But it could also be false or deceptive to tell someone that. I get his point, and she picked a different word. We don't have to go around in circles on it.
Did you believe Waters in his testimony in trial? Did you find him to be truthful?
Yes.
Would you agree there were questions about Waters' testimony?
Well, Gary Gishard raised questions about his testimony before the jury, but I believed his overall testimony to be truthful. I believed he was very remorseful, and he felt that the only way he could make it right was to come in and tell what happened. And that's what he said at the trial. And when I asked him why he pled guilty, he said, because this is the only way I can make this right.
September 11, 2000, in the arrest bond motion, you told the court, quote, the two, Mr. Singleton and Mr. Waters, approached the vehicle. Mr. Mraz stays behind in the driveway. They ordered Sergeant Wrigley and Mr. Blaylock out of the vehicle and ordered them on the ground. They were literally laying on the pavement on their stomachs as Mr. Waters and Mr. Singleton got into the vehicle, unquote. I reference the Mraz bond motion transcript, page 8, 2000-09-11. Is that true that you told the court that at that motion hearing?
I have no idea. I have no memory of it. If there's a transcript that I said that, then I said that.
So the court, if I'm reading to you from the transcript, is that possible that is what you did say?
Yes, show me the transcript. I'll be happy to let you. Show me the transcript. If it's in the transcript, I said it.
Wow, she's so rude. Dang, y'all got some bad attitudes. Gee.
Mr. Hort, I'm happy to assume for the purposes of today's record that Ms. Ross, in fact, said those exact words at the bond hearing for the third defendant. What would your follow-up question be?
Thank you, Your Honor. And looking for that document, I run across to page 8 in the Fulton County jury trial transcript. And that reads, Mr. Singleton had stolen a gun from a Fulton County Sheriff's deputy 3 days prior to this murder. It's a .40 caliber weapon, just at Fulton County Sheriff's Department.
What's happening right now? You're reading from a transcript. If I were present at the time, is this an opening statement to a jury? Is this Ms. Ross articulating something to Judge Downs or whoever the trial judge was?
I believe it's her opening statement. That's why I was trying to find a real reference to my question for Ms. Ross.
Opening statements were beginning at 359, not at page 8.
And I appreciate Mr. Armstrong's input. Maybe he can talk on transcripts.
Did you say page 8? Because there's nothing on page 8 other than court's exhibits. This would not be the trial. The trial transcript, page 8, is the court's exhibits, jury question 1 and jury question 2.
Okay.
That would most likely be a hearing.
Can you tell Mr. Armstrong where it's from?
I do not know which hearing that is the page 8 to.
It's from the Perez bond motion transcript.
Okay.
And so I'll go ahead and give you that page 8 out in the word screen. So, is that true? Did you tell the court on September 11, 2000 that Mr. Singleton, Mr. Wise approached the vehicle? They ordered Sergeant Griffith to display that kind of vehicle or on the ground.
Tyler, that's so true. They all got nasty attitude. That's a requirement. Have a nasty attitude.
I don't know the date of this transcript because there is no cover page, but it appears to be a transcript from a bond hearing. Don't know the date of it. And yes, it says, I said the two, Mr. Singleton and Mr. Waters approached the vehicle. Mr. Mires stays behind at the driveway. They order Sergeant Grigley and Miss Blaylock out of the vehicle and order them on the ground. They're literally laying on the pavement on their stomachs as Mr. Waters and Mr. Singleton get into the vehicle. Yes.
And you already get Mr. Armstrong?
Oh, no, I don't know what day it was filed. I don't know what you're asking me to look for.
You don't just choose between bond hearing. Okay, would you agree this is inconsistent with what was told the court on November 28th? And I will give you a copy of the page 11 transcript from that hearing.
And what was the hearing on November 28th?
It was a Perez bond motion.
Do you have more than one bond motion?
So it's page 11. The date of the hearing is 2000-11-28. And reading from the transcript, when they stumbled upon Sergeant Grigley and Debbie Blaylock arguing, it was Michael Waters who said, "This is our chance." And Michael Waters told the other two to wait in the driveway while he went in and perpetrated the crime, which you've heard about many times at this point, which we won't go back into. You understand that?
Well, that is a snippet of this hearing. So apparently I had said something earlier and I didn't want to repeat it to Judge Downs, who was a very impatient jurist. And so I summarized it. So I would not agree with you that 8 and 11 of 2 different transcripts on 2 different days are inconsistent statements. No.
So what I read to you from both hearings are consistent?
Let's assume for a minute that they're not entirely consistent. What is the relevance of that? We don't even know what page 8 is from.
Yes, we do.
Well, we don't. Mr. Armstrong thinks it's from a bond hearing, but now you're telling us actually page 11 is from a bond hearing for Mr. Mires. So maybe Mr. Armstrong was mistaken about where. It's not helpful to have pages fall from the sky not knowing what they're from. They're out of context, and it makes it really difficult for me to connect dots, for your witness to connect dots. This is a practice pointer. And instead of just having a page 11 from something or a page 8 from something, it would be better to have the something and say, let's turn to page 8 of that something. But that's an aside. Tell me the significance to the motion for a new trial for Leslie Singleton, not did Ms. Ross not quote herself verbatim between two hearings, that arguably those two statements are inconsistent. Where are we going?
I actually quoted to her, the court, Mr. Armstrong, from the September 11, 2000 motion transcript from Perez, page 8.
Okay.
So you have the date. The next date is November 28, 2000, page 11, Perez bond motion.
So two different bond hearings for the same guy.
Yes.
Okay. And in the second one, Ms. Ross is saying, okay, I've already told you a whole lot about this, so I'm going to summarize things. And clearly she had told Judge Downs a whole lot about it, because just a few months before, she went into a lot of detail. And so this time she summarizes, maybe in a way that is inconsistent. What's the point?
The point is, September 11, she told the court that Singleton and Waters approached the vehicle. They ordered Wrigley and Blaylock out of the vehicle.
I heard that part.
November 28th, she told the court, and Michael Waters told the other two to wait in the driveway while he went in and perpetrated the crime.
Okay.
Those are inconsistent.
Okay. And so what?
My next question then to her was, then looking back, should this have raised the red flag about Waters' testimony?
My answer to you is no, and it is not inconsistent. And it is not inconsistent for this reason, because the sentence immediately after the one that you just read says, the crime which you have heard about many times. And at this point, we won't go back into. And again, that is, I am summarizing for her. I'm not going to say it again because she's irritated with me, and I could probably tell that, which is why I went ahead and summed it up and kept moving. These are not inconsistent, and no, it does not raise a red flag.
I read that too. I didn't add anything to what I read.
Okay, but I'm hearing what you find to be inconsistent, because one, a pair of people approach the car and perpetrate the crime. And in the second bond hearing, words spoken by the prosecutor, not by Mr. Waters, are different. It is that Mr. Waters said, you two wait here, I'm gonna go do the deed. Those are different things, spoken by the prosecutor, not by Mr. Waters, not by Mr. Merez, not by Mr. Singleton, in a bond hearing, not in front of the jury, where that's the audience we're focused on. And it's the trial we're focused on, not the bond hearings. What is the so what of two different versions, similar but not exactly the same, of events shared with the judge for purposes of bond hearing?
Question. One, when we speak in front of the judge, we don't lie to the court, we don't lie to the judge. We tell the truth as we know it. Two, by telling the court two different things, that then raises a question about Waters' testimony.
Why?
If on the one hand, he said it was me and Singleton that run up to the car, and then the next hand, he says, no, Singleton and Merez stayed back there. That doesn't raise a question as to
that's two different
truthfulness of his testimony.
But in neither of what you read to me, does Ms. Ross say, I know what I know only because Mr. Waters told me? Or neither does she say, here's what Mr. Waters told me. You are attributing everything Ms. Ross had to say to Judge Downs exclusively to Mr. Waters.
And the reason why is just like when I talk to this court, I don't purposely lie to you. I try to tell you my understanding of the facts, and that's what she did there. And I'm saying with two very different versions of what happened, that should raise a red flag as to his testimony. She's saying no, okay, and move on.
Well, I'm sharing your observation that those aren't the same. One is two people go up to the car. The other is, no. Two of you stay back. I alone will go up to the car. Those are not the same thing. They're not consistent. What I'm not following you on is why that means Ms. Ross should distrust Mr. Waters. Maybe Ms. Ross should say things differently in front of Judge Downs if she doesn't have 15 other cases going on and she didn't remember exactly what she told Judge Downs before. And maybe she should worry less about Judge Downs getting impatient and saying, now I'm not going to listen to you. I probably would have that same concern, having dealt with similar situations. But you leap from that to say Waters is a liar. Or you, prosecutor, should not trust anything Waters said because you, prosecutor, said things that were different. How does that implicate Mr. Waters?
what I'm suggesting and arguing in our amended motion for new trial is that Waters testified falsely at the trial. And this recitation by the state's attorney supports that argument. It also supports as to why he should allow into evidence his letter and his affidavit, because there is a legitimate question about Waters' truthfulness at trial. And if it was not truthful at trial, we would submit there is ground number one, granting him a new trial, where you have a competent trial attorney and you have truthful witnesses.
Okay. Got it. You've connected the dots. Next question for Ms. Ross.
Thank you.
Hold on one second. What?
Mr. Singleton has his hand.
Oh, Mr. Singleton, you got a question?
Yes, I want to know if I could use the restroom, bring the camera down for a second, use the restroom.
So let's talk about schedule. That's a great question. We've got about 10 more minutes, and I have an afternoon full of other things. So this is how you've spent your morning. Are you close to wrapping up with Ms. Ross? It'd be great if she didn't need to come back, but I am not asking you to skip over anything. And obviously, Mr. Armstrong hasn't had a chance to ask Ms. Ross any questions. I suspect he'll have fewer than you did, but he may not.
I have here about 6.5 pages.
Okay. So that's probably more than 10 minutes worth. Okay. Are you coming close to a natural break point? This would be a time to break because Mr. Singleton needs it. But if you were going to be shifting in 2 more questions to a pretty different front with Ms. Ross, that might be a natural time to break.
Fine time to start.
Right here? Okay. Someone else came in and then left, your investigator. Was that someone who was going to testify? Had we made more progress this morning?
Yes, Your Honor, and noting the rule of sequestration, I asked.
No, you did that all right. I just wanted to make, because he'll be able to go soon, but you
Yes.
handled that just right.
Yes, Your Honor.
Okay. All right.
Mr. Dixon.
Okay, great. Just thinking logistically, I don't know when I will next have a window. I guess what you'll need to do, Mr. Hort, is make an estimate of how much more time, you don't need to do it right now, but make an estimate of how much more time you'll need with Ms. Ross, how long you think Mr. Dixon will be, if there are other witnesses, and then obviously the time of Mr. Singleton when he testifies. That may be too big a block to fit into one window that I have, but we could at least, I would like to have Ms. Ross have to come back only one more time. Same with Mr. Dixon. So let's fit them in the next block, assuming there's enough time for that. But I'm going to have you think through that and then confer with Mr. Armstrong so he can say, well, hey, I'm going to need a half hour with that person as well, or however long he's going to need, so that then you can get back to me and Ms. Hansberry with, I think I've got X hours left. And then we'll see, we'll break it into 2 pieces or whatever we need to do. That work? Okay. Mr. Armstrong, anything else you want to work through right now?
None from the state, Your Honor. I just point out that I do have a leave. I don't think you're expecting to do it the end of this week or next week, but I do have a leave of absence.
I'm sure well-deserved. We will work through leaves of absence. We'll also work with Ms. Ross's schedule. She may be in trial somewhere, in which case she can't come back here, but we'll do that in steps. You all get back to Ms. Hansberry and me with, we need X more hours. And if we're gonna just do Ross and Dixon, any other witnesses other than Mr. Singleton, we need this many hours to do that. Then we'll come up with some possible dates. You can consult with your witnesses to see which of those dates work for them and with your schedules.
I would just like to mention something out of an abundance of caution. Every once in a while, for different cases, I have to talk with Ms. Ross. I will not talk to her about this case, but if I have communication with her between now and then, I'll just mention it to the court.
Great. I appreciate you flagging that. Careful as always.
Is it okay if she takes back with her those documents?
If they're copies for her, she can have them. See, she's leaving with the door prize.
Well, can I get complete transcripts?
Um,
This is page 8, this is page 11.
right,
I
we'll-
like complete transcripts.
Right, well, we'll work on that. I'm assuming there's a complete transcript and you didn't just find 11 and 8. So if you can get those, either, I guess you know how to reach Ms. Ross because you lined her up to be here today, but you or Mr. Armstrong should please get to her all of those 2 transcripts?
If I can find them, I will email them to Ms. Ross, CC to Mr. Hort, so it would not be a communication just between me and Ms. Ross now that she's testifying.
Sure. Obviously, you guys include each other on the emails. Someone must have them because we have page 8 and 11.
Oh, I've read them. I just don't have them in an easy way, and I have them generally by like when they were filed and things of that nature. You can find them honestly quickly that
We
way.
help with those dates, so that should make them easier to file.
I very easily have it, so I can.
Good. Please do. Whole transcript to all of us.
And to court too.
Why not?
Can I use your office email address as well?
Yes.
All right. Anything else?
No.
Mr. Hort? Okay. Mr. Singleton, you're about to get that restroom break, but you'll get more than that. You have any questions about what's been going on so far, other than when are we going to meet again?
No, I'm just waiting to get my opportunity to answer a line of questions, and that's it.
Got it. It's coming. Mr. Hort is methodically working through other witnesses that lead up to your testimony. So we will get that soon enough. All right.
Understood.
All right. Thank you to the folks at Coffee Correctional for getting you on, as well as to Ms. Willis, if she's still on, for lining this stuff up. Thank you, everyone. See if I have a different Zoom for this afternoon. I do, so I can end this.
Mr. Hort, I think that is your exhibit, but I just wanted to let you know about it before you walked away. No.
All right, y'all. Hold on. Sorry, guys. I went downstairs. Sorry. You said I don't know what's going on. Hold on, y'all. How long this stopped? Because I was downstairs trying to handle something with Dallas. Did the judge make a decision? Oh, Mullins is on lunch break. Can't do Mullins either. Mullins is on lunch break. I thought we was late to the back. No, you're not late to the back. I haven't even started. We're still doing. I said after these hearings. I said after the hearings. I said not before, but after. After the hearing, I said. Because some folks are at work, some folks are just not around. This will be after. No. Did you hear what I said? I said the other trial is on lunch break. They are on lunch. I guess y'all must be coming in here late because you see, they're on lunch break. They are on lunch. They're on lunch. Y'all must be on delay or just not paying attention to what I said. I don't want to rewind. Because I got stuff I need to take care of over here. Because as soon as I rewind, y'all be trying to figure out what's going on. And how about if I just end it and then, how about that? I be getting texts, phone calls as soon as something goes on and I'm not over here. You guys be very demanding. Okay, that's what Mimi. I can do that one. Hold on, let's do let's do Robert Brooks. Hold on a second. Gosh, I got stuff to do around here, y'all. Y'all know that, right? Today was just supposed to be a what's the name day for me to and I get stuck on here all day and I don't get a chance to do my household chores. Don't get a chance to do my household chores and I gotta get done. There's some stuff I need to take care of. I got a lot of stuff to take care of. So it's only one of me. Got a lot of stuff to take care of. Y'all at work already. I gotta get my stuff together over here. I got a lot of stuff to do. Lots of stuff to do. Y'all over there at work. I have to where is it? Oh, Jesus. Build a fence all around me every day. Won't you protect me as I travel along the way? Yes, Lord, I know you will. Oh, God, Jesus. What did I forget? I didn't forget nothing. This thing says I forgot something. Yeah, this is the court hearing of Robert Brooks. Hold on a second, let me stop this. Okay, this just. This is with the correctional officers that killed a guy that was in custody. Robert Brooks.
All right, the court will permit the same.
Right, I think this is it.
And/or will be supplied to you shortly, and then have a pretrial conference to discuss scheduling of motions and things of that nature. March 31st, 9:30 a.m.
When the name is redacted from the indictment because that individual not yet in custody. I'm also hearing him over standard pretrial notices. But I've included an IAD notice, even though there were no formal identification procedures here. The ID notice is self-explanatory. It has to do with people who testified in front of the grand jury that you videotaped, but this is all indicated that this person, such and such, don't know that it will be the subject of hearing on relevant. Mr. Franco, take care of that.
Understood.
I do acknowledge your honor.
Thank you. All right, and with that, did either side want to be heard on the question of bail? Mr. Fitzpatrick.
Cash or $250,000 bond.
Oh, okay. Mr. Fitzpatrick, we're having some difficulty hearing you. I'm going to ask you if you use the podium that has a microphone available to you. We'll get that over closer to you. Mr. Sifranco, did you want to be heard on that topic?
Why they all can't use a podium? You still, what is up with the courts with the mics?
Not have a valid passport when he was surrendered, not that office, no jurisdiction, it's all intentions of being in court every time it's surrendered. Bail as requested by the jury. All right, the court has considered the statutory factors, and I do take particular note of the reality that if the defendant were convicted of the top count contained in this indictment, he faces a sentence of as much as 25 years to life in state prison. Accordingly, bail is set in the following amounts. That is $100,000 cash, $250,000 insurance company bail bond, or $1 million partially secured surety bond with a minimum 10% deposit. Do I understand correctly, Mr. Sifranco, you have a bondsman available? All right. Mr. Bernardo, if you have that paperwork complete, I will review the same.
He got so much going on over there. Got the phones ringing. Sound like doorbell. Terrible mic. He got handcuffs on? Oh, yeah, he does have handcuffs on.
Officer, would you do me a favor and pass that over to Mr. Sifranco as well? Yes, you may. Thank you. All right, and before me now is Bondsman Jay Bernardo. Mr. Bernardo, you swear the truth of the content of your bail undertaking and affidavit. Is that correct? Thank you. Mr. Anzalone, confirm for me you signed the bail undertaking here as well? Yes. All right. And Mr. Anzalone, I have before me now a proposed bail bond in the amount of $250,000, and I understand you're asking to be released upon this bond. Do I have that right? Yes. You understand what your number one obligation is under this bond? Yes. What is that? Court. Exactly, return to court. Some things I want to make sure you understand. First, you do have a right to be present at all stages of proceedings in your case, but if for some reason you did not come back to court as required, then a warrant would be issued for your arrest. The bail that you're posting by way of this bond, that would be forfeited and lost. You would then face a new felony charge, and that's known as bail jumping. Your case could then proceed in your absence. That means you could be tried in your absence, and if convicted, sentenced in your absence as well. You understand? Yes. I have received now a document entitled Parker Warning, outlining the warnings that I just gave you in writing. You signed this document here as well after reviewing it with your attorney. Is that right? Yes. Court is signing and approving the bail bond. Transport gentleman can have that. Mr. Anzalone, you're due back in this court March 31st at 9:30 a.m. for a pretrial conference with your attorney. I will see you back here then. Sure. Anything further from either side? All set then. Thank you, counsel.
Need people yelling in the background.
David Walter.
Not back, folks, up there, you feel attack. No fail. White racist white boy prison guard. They let him go.
Mr. Pastelacqua, you're representing David Walters? Yes, Your Honor. All right, so I do have a number of requests from the news media to cover today's proceedings by audio, visual coverage, as well as still photography. Do you have any objection? No, Your Honor. Fitzpatrick, no objection. The court will permit the same. Yes.
Where's that other guy at? Look at that judge's hair. What's up with the judge's hair? Is that a toupee? Or is his signature gray?
Understood, Your Honor. Absolutely.
Good afternoon, Your Honor.
Mr. Starzewski, any objection to the media coverage here today?
No, Your Honor.
Mr. Fitzpatrick, can I assume you have a continuing no objection? All right, very good. The court will permit the same. Yeah, do you have Farina? We'll take Farina, please.
You have to get the inmate. Look how quick that man went across there in that fast space. I heard somebody yawning.
Excuse me. You guys just noticed something on the audio. We can't hear what's going on in the court.
This is the matter of the people against Anthony Farina, indictment 25035, on for arraignment today. I've received correspondence from a James Riotto that he's been retained in this matter. Are you?
Yes, Judge, I'm here up, counsel.
Very good. Thank you, Mr. Starzewski. All right, and that's your name, sir, Anthony Farina? How old are you, Mr. Farina?
49.
Mr. Farina, you are here today because the grand jury of Oneida County returned an indictment against you, so you have to be arraigned upon that. Mr. Fitzpatrick, you may arraign.
Thank you, Your Honor. Mr. Farina, in indictment 2025-35, you have been indicted by an Oneida County grand jury charged with various crimes, the top count of which is murder in the second degree. The counsel, I'd ask if you waive a formal reading of the indictment. Waive a reading, answer plea, not guilty to all charges.
Not guilty plea is entered on the defendant's behalf.
This time, Judge, I'm going to hand counsel a copy of the indictment, again with the admonition that one name has been redacted because that individual is not in custody. I'm also providing our standard pretrial notices along with a disc concerning certain statements made by Mr. Farina and ask if knowledge received. Knowledge received, Your Honor.
All right. What I'm going to do, Mr. Starzewski, is adjourn the matter to March 31st at 9:30 a.m. for a pretrial conference to give you some time to review the discovery materials. At that time, I can set up a motion schedule for you as well. Will that be you or Mr. Riotto at that time?
Probably Mr. Riotto.
Very good. All right. And with respect to the topic of bail, Mr. Fitzpatrick?
I would ask, Your Honor, bail consistent with what you said on Mr. Anselmo.
Mr. Starzewski, your thoughts?
Pardon.
All right, the court's considered the statutory factors and taking particular note of the fact that the defendant, if convicted of the top count, could face a sentence of as much as 25 years to life in state prison. Bail is set in the following amounts. That is $100,000 cash, $250,000 insurance company bail bond, or $1 million partially secured surety bond with a minimum 10% deposit. Officer, if you please pass this over. Mr. Starzewski, I'm going to have you provided with a Parker warning to review with your client.
Thank you.
Mr. Farina, you do have a right to be present at all stages of proceedings in your case, but if for some reason you posted bail and then did not come back to court as required, if your arrest, the posted bail will be forfeited and lost. You may then face a new felony charge known as bail jumping, and the case may proceed in your absence, meaning you could be tried in your absence, and if convicted, sentenced in your absence as well. You understand that? I've received this document entitled Parker Warning, which outlines in writing the warnings that I just gave you. Confirm for me you signed this document after reviewing it here with your attorney today. Thank you. All right, bail is set. The amount so indicated. The defendant's to return to court on March 31st at 9:30 a.m. Is there anything further from either side?
No, Your Honor, thank you. Yes, Your Honor, I'd ask that defendant surrender his passport to counsel, and counsel advise me of when it has been surrendered. Suggest a week to do that. We'll make that happen.
Very good. If you please notify the court when that's complete.
I will.
Very good. Thank you.
You're welcome.
Surrender his gun too. The fuck?
All set. He's committed.
So they all get there. That a bitch.
Matthew Gallagher.
Matthew Gallagher.
Actually, you can't lie. Sorry, under these circumstances. Good. Thanks. It's Mr. Louisbrand, is it?
Yes, good afternoon, Your Honor.
Good afternoon. Mr. Louisbrand, I have a number of media requests here for audio, video coverage, and still photography. Do you have any objection?
No objection, Your Honor.
Court will permit the same. The matter of the people against Matthew Gallagher, indictment 25035, on for arraignment today. I understand, Mr. Louisbrand, you've been retained to represent Matthew Gallagher. Is that right?
Yes, Your Honor.
That's your name, sir, Matthew Gallagher?
Yes.
How old are you, Mr. Gallagher?
43.
Mr. Gallagher, you're here today because the grand jury of Oneida County has returned an indictment against you. You must be arraigned upon that indictment. Counsel, you may arraign.
Thank you, Your Honor. Mr. Gallagher, an indictment 2025-35 in the Oneida County Grand Jury has charged you with various crimes, the top count of which is murder in the second degree. And I'd ask counsel if you waive a further reading of the indictment.
Yes, we do, Your Honor. We enter a plea of not guilty and waive reading of the indictment.
A not guilty plea is entered on the defendant's behalf.
This time, Judge, I'm going to hand counsel a copy of the indictment with one name redacted, along with our standard pretrial notices, including a disc containing statements allegedly made by Mr. Gallagher, and ask you to acknowledge receipt of those.
Thank you, Your Honor. Give the documents and I acknowledge receipt.
All right, in that case, it's the court's intention to adjourn the matter to the morning of March 31st, 9:30 a.m. for a pretrial conference. I'll give you time between now and then to review the discovery materials and set a motion schedule at that next appearance. With respect to bail, what's the position of the people?
Your Honor, we recommend bail consistent with what you said on Mr. Anzalone and Mr. Farina.
That's bullshit.
Mr. Louisbrand, your thoughts?
We would join in that request, Your Honor. I would add that Mr. Gallagher is a lifetime resident of the area. He has family local, 2 young children and a wife.
He's worked throughout the area. He has no criminal record whatsoever, Your Honor. All right, the court's considered the arguments of counsel and the statutory factors, and noting that the defendant could face a sentence of as much as 25 years to life in state prison if convicted after a trial of this matter. Bail is set in the following amounts: $100,000 cash, $250,000 insurance company bail bond.
You hear them yelling in the background?
$1 million partially secured surety bond with a minimum 10% deposit. Mr. Gallagher in a position to post that bond today, or did you need to schedule that?
He's prepared. Mr. Bernardo has agreed to provide the bond for us on behalf of Mr. Gallagher.
Of course. That's that union money.
I'll pass a Parker warning over. You can review that with your client.
You hear them talking? They said that's that union money. Did y'all hear them say that?
That's that union money. Them niggas ain't got that kind of money, man. Taxpayers' money. Catch and release.
Where are they talking from this? Y'all hear them?
Thank you. All right. Before me now is bondsman Jay Bernardo. Mr. Bernardo, you swear the truth, the content of your bail affidavit and undertaking?
Good night, Serena.
Yeah, Mr. Gallagher signed the same.
How do you live with yourself? How do you tell your kids this? Your kids gotta watch this. You probably don't even let them watch it.
How are these people talking on this thing, y'all?
Killing. That's what it is.
How are they talking on this?
He beats on helpless, innocent black men in prison.
Where is this coming from?
Swore to uphold and defend the Constitution.
All right, so Mr. Gallagher, I have before me now a proposed bail bond in the amount of $250,000. I understand you're asking to be released upon this. Is that right? Do you understand what your number one obligation is under this bond? Exactly right. You do have a right to be present at all stages of proceedings in your case. If you do not come back to court as required, then a warrant will be issued for your arrest. The bail you're posting by way of this bond will be forfeited and lost, and you'll then face a new felony charge, and that's known as bail jumping. Your case may then proceed in your absence. That means you could be tried in your absence and if convicted, sentenced in your absence as well. Do you understand that? Now, the warnings I just gave you were just provided to you in written form by way of this document entitled Parker Warning. I'm holding the same up for you. Confirm for me that you did sign this document here after you reviewed it.
He got his phone streaming it. Yeah, whoever this guy is, he's streaming
For
it.
the signing and approving the bail bond.
Hey, Rob.
If you're released on the bond today, you're due back in this court on March 31st at 9:30 a.m. Thank you. All set. Thank you.
Thank you.
Yeah, this case is going to be lit. I wish I can go to this case.
They be unsealed 2 indictments, right?
Look at that guy with the phone. Look how he's streaming it with his phone. Look. Ah!
At least it ain't manslaughter.
See the guy with the beard over there on the left-hand side next to the guy with the blue suit? He's streaming with his phone.
St. Walter's down
That judge is killing me with that hair. That hair. They said Sylvia was he loved providing
picture.
there. Yes. Down there, right?
Oh, he was live providing commentary. Okay, okay. Yeah, it's beautiful out here in the weather. Yeah, his arm probably tired, but see me, I would have bought a the camera guy behind him is got a stand. I would have bought my little small stand if I was him. That courtroom seemed snug. We had him yawning all loud and everything. Lord have mercy. Somebody's typing.
Oh, shit.
Walrath or Fisher, they're both up here.
Christopher Walrath.
So to begin, Ms. Hartwell, I do have a number of requests from news media for audio and video coverage of today's proceedings, as well as still photography. Do you have any objection?
No objection, Your Honor.
Court will permit the same. Sir, your name is Christopher Walrath?
Yes, sir.
So, Mr. Walrath, you're charged under indictment 25035 with the felony offenses of murder in the second degree as well as manslaughter in the first degree. On these charges, you're entitled to the assistance of counsel at this and all stages of proceedings. If you cannot afford an attorney, one will be provided to you at no cost to you. Ms. Hartwell here is with the Public Defender's Office. If you qualify for her services and you like, I can assign her to represent you. Is that your wish?
Yes.
Do you at least preliminarily qualify, Ms. Hartwell?
Yes, Your Honor, he does.
All right. And at this time, Ms. Hartwell and her office will be assigned to represent you. I'll just note, Mr. Walrath, that is subject to your it being verified that you are financially eligible for assignment of the Public Defender's Office and that we do not have a conflict of counsel develop as the case moves forward. I just want to make sure you understand that. With that, you're here today to be arraigned on indictment 25035. And Mr. Fitzpatrick, you may arraign.
Mr. Wallace, in indictment 2025-35, you've been charged by an Oneida County grand jury with various crimes, the top count of which is murder in the second degree. Counsel asks if you waive a formal reading of the indictment.
I will. Yes, thank you.
This time, Your Honor, I'm going to hand counsel a copy of the indictment with one name redacted because that person is not yet in custody, along with our standard pretrial notices, and ask if you acknowledge receipt of that.
Do I acknowledge receipt, Your Honor?
And enter a plea.
Yes, Your Honor, we enter pleas of not guilty.
A not guilty plea is entered on the defendant's behalf. I'm going to adjourn the case to March 31st at 9:30 a.m. for a pretrial conference and to set a motion schedule. With respect to the topic of bail, what's the position of the people?
We would ask for bail to be set consistent with that of Mr. Ganzalone, Mr. Farina, and Mr. Gallagher, Your Honor.
Ms. Hartwell, your thoughts?
Your Honor, with regard to that, I'm just only asking the court to consider the reasonable bail based on the information that the court has received, as well as the fact that my client is a lifelong resident here in the area of New York State, and I do not believe is a flight risk.
Officer, would you mind passing this over to Ms. Hartwell, please? Court has considered the arguments of counsel as well as the statutory factors, taking particular note of the reality that if the defendant were convicted of the top count contained in the indictment, he could face as much as 25 years to life in state prison. Bail is set in the following amounts. That is $100,000 cash, $250,000 insurance company bail bond, or $1 million partially secured surety bond with a minimum 10% deposit. Now, Mr. Walrath, if you do make bail and you're released while these charges are pending, you do have a right to be present at all stages of proceedings in your case. If you do not come back to court when required, then a warrant will be issued for your arrest. The bail posted would be forfeited and lost. You would then face a new felony charge that's known as bail jumping. And the case may proceed in your absence, meaning you can be tried in your absence and if convicted, sentenced in your absence as well. Do you understand?
Yes.
There's a document in writing to that effect of the warnings I just gave you. Please take a moment to review the same with your attorney, and then you may sign.
Alien nation skinhead. You are the area skinhead racist white boy.
For the record, the defendant has executed the original of the court's written Parker warning. The matter is adjourned now to March 31st at 9:30 a.m. for a pretrial conference.
Thank you, Your Honor.
Thank you.
I would ask the court ordered defendant to surrender his passport to counsel and that she advise the court and special prosecutor when that's done.
All right. Understood. Thank you. Thank you. He's all set.
Family, friends, union.
So then he has to get a public defender then.
bail than a public defender. Pay for the attorney. Get me out. I'm not guaranteed he gonna survive. Another one got a PD. That's a compliment.
Out of the people against Michael Fisher under indictment 25035 on for arraignment today. That's your name, sir, Michael Fisher? How old are you, Mr. Fisher? 54.
54. You still doing that dumb shit, bro?
Mr. Fisher, you're here today because the grand jury of Oneida County returned an indictment against you. You are charged with one count of the felony offense of manslaughter in the second degree. On this charge, you're entitled to the assistance of counsel at this and all stages of proceedings. If you cannot afford an attorney, one will be provided to you at no cost to you. Ms. Hartwell here is with the Public Defender's Office. If you qualify and you like, I can assign her to represent you. Is that your wish?
Yes, please.
He qualifies.
He does, Your Honor. Preliminary qualifies for public defender services.
All right. So, Mr. Fisher, I'm assigning Ms. Hartwell today so you understand. Conditionally, that is that you're going to ultimately, after they get a further review of your finances, properly qualify for assignment of counsel. And then I'm going to have to look into whether or not a conflict exists and they need to assign you counsel. You understand?
Yeah, conflict doesn't exist.
You can stand in for arraignment today.
Yes.
Very good. And we'll proceed with the arraignment. Mr. Fitzpatrick, you may arraign.
Thank you, Your Honor. Mr. Fisher, in indictment 2025-35, you have been charged by an Oneida County grand jury with a single crime of manslaughter in the second degree. Counsel, I'd ask if you waive a formal reading of the indictment. Your Honor, at this time, I'm going to hand counsel a copy of the redacted indictment, redacted only with one name being removed, along with our standard pretrial notices, along with a disc containing statements allegedly made by Mr. Fisher, and I'd ask if you acknowledge receipt of those items.
You should get murdered. For real. Murder. Right. Are you paying your bill?
There's no conspiracy charges, none of that. But what happened to the conspiracy charges?
A not guilty plea is entered on the defendant's behalf. This matter will be adjourned to March 31st at 9:30 a.m. for a pretrial conference and setting a motion schedule.
Not one fucking conspiracy charge.
Fitzpatrick, did you want to be heard off topic of bail?
Yes, Your Honor. I would ask, we have the people, bail be set in the amount of $25,000 cash or $100,000 bond. And I'd also ask, as with previous arraigned defendants, that Mr. Fisher surrender his passport to counsel and she advised the court and the special prosecutor of same.
Is there a passport to surrender?
No, he does not, Your Honor.
Ms. Hartwell, your thoughts on bail?
Your Honor, with regard to bail, again, I would ask the court to consider reasonable bail in this matter. I do see that Mr. Fisher is not charged with 2 counts, but only 1 count. And he is a lifelong resident of the state of New York, and he is not a flight risk. As I've just indicated, he does not have a passport, and I can assure that he will not be a flight risk, and I ask the court to consider bail slightly lower than what's been recommended.
The court's considered the arguments of counsel in noting that the defendant could be sentenced to as much as 5 to 15 years in state prison if convicted after a trial. Bail is set in the following amounts: that is $50,000 cash, $100,000 insurance company bail bond, or $500,000 partially secured surety bond with a minimum 10% deposit. If I understand correctly, Mr. Bernardo is in a position to post a bond today. All right, when you have your paperwork ready, I'll review the same. Officer, if you don't mind passing that over for me, thank you. Here. Just gotta get the dollar amount in here, right? Oh, I know.
Got out of the car, covered it up with the fire department.
Bernardo, Mr. Bernardo, you swear the truth of the content of your bail affidavit and undertaking, is that correct? Signature, please. Thank you. All right, Mr. Fisher, I have before me a proposed bail bond in the amount of $100,000, and I understand you're asking to be released upon this. Is that correct?
Yes.
Do you understand what your obligation is under this bond?
Yes.
What's that?
Show up or lose everything.
Exactly right. Yeah, you have to come to court or this bond will be forfeited.
Won't be a problem.
Very good. So I'm going to advise you of your warnings relative to that. You do have a right to be present at all stages of proceedings in your case. If you do not come back to court when required, then a warrant will be issued for your arrest. The bail being posted by way of this bond here today, that would be forfeited and lost. You'd then face a new felony charge known as bail jumping, and the case could proceed in your absence, meaning you could be tried in your absence and, if convicted, sentenced in your absence as well. You understand?
Yes, sir.
I've received a document entitled Parker Warning that outlines those warnings I just gave you in written form. Confirm for me you signed this document here after reviewing it with counsel today?
Yes.
Court is signing and approving the bail bond. You'll be released on the bond here today. Mr. Fisher, you are due back in this court on March 31st at 9:30 a.m. So, thank you. Also, thank you.
Judge, I'll check the progress of the others.
Got it.
Take a look again, Kyle.
Defense counsel, I'm going to mispronounce your name unless you help me. Nociolo. Counsel, do you have any objection to the immediate coverage of today's proceedings? All right, the court will permit the same. This is the matter of the people against Nicholas Gentile, indictment 25035 on for arraignment today. And counsel, it's Julie Nociolo, correct? You've been retained to represent Nicholas Gentile? That's your name, sir, Nicholas Gentile?
Yes, sir.
How old are you, Mr. Gentile?
36 years old.
Mr. Gentile, you're here today because the grand jury of Oneida County returned an indictment against you. You have to be arraigned upon that. Counsel, you may arraign.
Thank you, Your Honor. Mr. Gentile, in indictment 2025-35, an Oneida County grand jury has charged you in the 8th count of said indictment with tampering with physical evidence, violation of section 215.40, subdivision 2 of the penal law. And Ms. Nasiolo, I ask you to waive a further reading of the indictment. Your Honor, at this time, I'm going to hand counsel a copy of the indictment redacted with one name missing, along with our pretrial notices and demands, et cetera. I ask you to acknowledge receipt of those items.
Acknowledge receipt, Your Honor.
And enter a plea.
Enter a plea of not guilty on my client's behalf.
A not guilty plea is entered on the defendant's behalf. Court will adjourn the matter to March 31st at 9:30 a.m. for a pretrial conference in the setting of a motion schedule.
Is this the last one, y'all?
What are the people's thoughts with respect to the defendant's release status?
Yes, Roberta Flack passed away.
Case where you can't
Roberta Flack passed away at age 88.
Any conditions to the court's discretion.
All right. Do you want to be heard on that topic, Ms. Nociolo?
Briefly, Your Honor, with respect to any conditions, I agree obviously with the people. This is a non-qualifying offense. Mr. Gentile has been a lifelong member of this community, has a wife and 2 kids, has retained me as counsel, and we ask therefore that he be released on his own recognizance.
All right, the court's considered the arguments of counsel and the bail statute being what it is at present. This does constitute a non-qualifying offense, such that bail may not be set on this particular charge. Mr. Gentile, that means I'm going to be releasing you on your own recognizance, which effectively means on your promise that you will return to court when required. Do you promise me you'll do so?
Yes, Your Honor.
Understand that if you were to break that promise and not come back to court as directed, then you're subject to having release on your own recognizance revoked, and that means you could then be committed to the jail with or without bail, so I'll be assured you do come to court when required. Do you understand that?
Yes, sir.
I'm going to pass over a document entitled Parker Warning that outlines your obligations in that regard.
So where's the nurse? Where's the nurse?
They asking for a nurse.
For the record, the defendant has executed the written Parker warning here in court. Mr. Gentile, keep in touch with your attorney. You'll be back in this court on March 31st at 9:30 a.m. Thank you.
Okay, that's the last one, right? That's the last person, right?
They were all the same fucking thing.
Because I'm ready to go to the other court now, back to Iowa. Iowa is back from lunch.
I'm Sicilian and don't let this lily like skin for you. Oh. No, I don't do that way you do shit.
Somebody said they Sicilian.
Yeah. Oh, you're in order. Oh.
Well, it's the what's the reporters are talking, y'all. You see them talking to each other.
My dad did. Yeah.
All right, I'm gonna switch over to the other court now because it seems like they just
Coming up. Thank you.
hold on. They should be done.
Give it a Kingsley. You can give me a call back at 732.
Oh, this must be the last guy there. That guy bigger than all the police officers there. Look how little that police officer is behind him.
This is the matter of the people against David Kingsley, indictment 25035. At the outset, Ms. Hartwell, do you have any objection to media coverage?
No, Your Honor.
Court will permit the same. And sir, that's your name, correct? David Kingsley? Yes. So, Mr. Kingsley, you're here today because the grand jury of Oneida County did return an indictment against you. You are charged with one count of the felony offense of murder in the second degree and one count of the felony offense of manslaughter in the first degree. On these charges, you're entitled to the assistance of counsel at this and also.
Oh, wow, they clapping on him.
One will be
What in the
provided
world
to you
is
at no cost
that?
to you. Ms. Hartwell, does he qualify
Yes, Your Honor.
preliminarily?
Preliminary qualified for public defender services.
And with that,
Oh, that's
Mr.
how he
Finelli, are you in a
qualified.
position to take an assignment?
You hear them in the background?
Yes.
They are so rude back there.
Why don't I have counsel approach, please?
Dang, what the heck is going on in there? They fighting over there, huh?
What you gonna beat me up too? Yeah, but you didn't say nothing to the right. You said something else. When we told you to shoot me, it was her. She got kids. He got kids. We got kids. You killing our kids. You killing our kids. People get in jail and they get murdered. That ass. You stomping the man up and do these kids.
That's right.
And she was over here, came over here messing with us. We wasn't saying shit to her.
Oh, there they go, y'all.
Nobody cares. And I want to know why bills too. And we still got to pay a high bill. Or that. We got the same shit you guys got. Y'all never wanted that before, but now you guys are back. Before now. Don't talk to none of us inside. Single black mother. Nobody over here is bothering you. No one's trying to hear your mom over here talking to us nonstop. We had a house in the same time. Why you qualify for a bill? And why did Mr. Fitzpatrick give out $750,000 bail to a drug raid in Syracuse on Richmond Ave, but his murder is $250,000 bail? When you give a drug raid $750,000 bail for 300 people? Bullshit.
It's a mockery of
Gave my son's murder $50,000 bail. Manslaughter.
So, Mr. Kingsley, you are entitled to the assistance of counsel throughout these proceedings, and if you cannot afford an attorney,
Oh my
do
God.
you intend to retain counsel, or would you like counsel assigned? All right, and I understand, Ms. Hartwell, maybe at least preliminarily that. All right, in that case, Mr. Kingsley, I do have attorney Matthew Finelli here. I'm going to assign him at this time as your attorney for purposes of today's arraignment. That's a conditional assignment insofar as I understand the public defender's office is going to complete their review of your financials to ensure that you are in fact eligible for assigned counsel. You understand? All right, with that, then I'll ask Mr. Finelli to step up and I'll thank Ms. Hartwell.
These individuals will show me correct credentials. If you can provide me credentials, I'll let you record. How about that? Thank you, sir.
Mr. Finelli, you're welcome to turn the microphone off and take a moment to confer with your client. Thank you very much.
Yeah, they are going in over here.
All right, so Mr. Kingsley, the reason for your appearance here today is because the grand jury provided account returned an indictment against you, so you have to be arraigned upon that. Mr. Fitzpatrick, you may arraign.
Thank you, Your Honor. First, I apologize to the court, but I'd like to amend the indictment to reflect the correct spelling of Mr. Kingsley's name. In the head note of the indictment and in count 1 and count 2, Mr. Kingsley's name should be spelled Kingsley.
I see that a couple of letters were transposed. No objection, Mr. Finelli.
No objection, Your Honor.
The court will permit the amendment.
Mr. Kingsley, in indictment 2025-35, you've been charged by an Oneida County grand jury with various crimes, the top count of which is murder in the second degree. And I'd ask Mr. Finelli if you waive a formal reading of the indictment.
I do waive.
This time, Your Honor, I'm going to hand Mr. Finelli a copy of the redacted indictment with one name missing, along with our standard pretrial notices, as well as a disc containing statements allegedly made by Mr. Kingsley, and ask if you acknowledge receipt of those items.
I acknowledge receipt.
And enter a plea.
My client wishes to enter a plea of not guilty.
Not guilty plea is entered on the defendant's behalf. This matter will be adjourned to March 31st at 9:30 a.m. for a pretrial conference and setting up a motion schedule. And did either side wish to be heard on the question of bail? Mr. Fitzpatrick.
I'd ask that bail be set consistent with Mr. Anzalone, Mr. Farina, Mr. Walworth, Mr. Gallagher, and that Mr. Kingsley surrender his passport, if he has one, to Mr. Finelli at his earliest convenience, and notify the court and the special prosecutor when that is done.
Mr. Finelli, does your client have a passport?
Your Honor, I believe he does have a passport, correct? Do not have a passport. Does not have a passport.
All right, and your thoughts on bail, Mr. Finelli?
Your Honor, I just ask that you take into consideration, it's my understanding that my client is a family man. He is a lifelong resident of Jefferson County.
So was Robert Brooks a family man, motherfucker?
I would ask that the court take those considerations when setting bail.
Courts considered the statutory factors as well as the positions of counsel here this morning, and I do take particular note of the fact that if convicted after a trial of the top count here, the defendant does face as much as 25 years to life in state prison. Accordingly, bail is set in the following amounts. That is $100,000 cash, $250,000 insurance company bail bond, or $1 million partially secured surety bond with a minimum 10% deposit. We'll pass over a written Parker warning. Mr. Kingsley, some things to understand, sir. You do have a right to be present at all stages of proceedings in your case, but if you did not come back to court when required after posting bail, then a warrant would be issued for your arrest. Any bail posted would be forfeited and lost. You then face a new felony charge known as bail jumping, and your case could proceed in your absence, meaning you could be tried in your absence and if convicted, sentenced in your absence as well. You understand? Counsel, please take a moment to review that with your client and have him execute the same.
Your Honor, just for the court's notice here, there appears to be a typo here in this Parker warning. It indicates that sir is the third, David James Kingsley the third. He is not the third.
You can amend that then. Thank you. For the record, the defendant has executed the written Parker warning here in court. The matter is now adjourned to March 31st at 9:30 a.m. I will have you back then, Mr. Kingsley. He's all set. Thank you.
Hold up to me, we being peaceful. We want this peaceful, but by any means necessary. No.
David Butcher. Right. Which one?
They gonna drag this shit out for years, bro.
I don't even know if he was there. Because I really do not.
Thank you for waiting, Mr. Passalacqua.
Absolutely, Your Honor.
Continue to have no objection to the media.
Yes.
Very good, thank you.
I'm not feeling it. It was off for a show when he was camping. It was for a show when they put over his package.
Oh, he looks racist. Like he's about to fucking like him. Skinhead.
This is the matter of the people against David Walters, indictment 25035 on for arraignment today. Mr. Passalacqua, do I understand correctly you've been retained to represent David Walters?
Yes, Your Honor. On behalf of Passalacqua and Associates, we have been retained to represent Mr. Walters.
Thank you. That's your name, sir, David Walters?
That's correct, sir.
How old are you, Mr. Walters?
36.
Mr. Walters, you're here today because the grand jury of Oneida County returned an indictment against you. You have to be arraigned upon. Mr. Fitzpatrick, you may arraign.
Thank you, Your Honor. That's Mr. Walters, in indictment 2025-35, an Oneida County grand jury has charged you in the 6th count of said indictment with the crime of manslaughter in the 2nd degree. Mr. Passalacqua, I'd ask if you waive a formal reading of same.
I will.
I'm going to hand defense counsel a copy of that redacted indictment along with our standard pretrial notices as well as a disc containing statements allegedly made by Mr. Walters to law enforcement.
I would acknowledge receipt, Your Honor. Now, your formal proceedings entered plea of not guilty to all charges at this time.
Very good. A not guilty plea is then entered on the defendant's behalf. The matter will be adjourned for a pretrial conference to March 31st at 9:30 a.m., at which time, if necessary, I will also set a motion schedule. And Mr. Fitzpatrick, your thoughts on bail?
I would ask that bail be set consistent with that set on Mr. Fisher, and that if Mr. Walters has a passport, he surrender it to his attorney and his attorney notify the court and the special prosecutor of same.
Passalacqua, does your client have a passport?
He does not, Your Honor.
All right. And your thoughts then on bail?
Yes, Your Honor. I would ask the court to consider setting bail lower than has been previously set. Mr. Walters has been a lifelong resident of the area, does not have a passport, does not recall the last time if he ever left the country at all. He's retained my office. He's been in constant contact with us. We've maintained constant contact with Mr. Fitzpatrick's office throughout these proceedings and leading up to today's arraignment. He poses zero flight risk, and I would ask the court to consider those factors in setting bail.
Thank you. The court's considered the statutory factors as well as the position of counsel here this afternoon, noting that if convicted of the sole count the defendant faces under this indictment, he could face 5 to 15 years in a state prison facility. Bail is set in the following amounts. That is $50,000 cash, $100,000 insurance company bail bond, or $500,000 partially secured surety bond with a minimum 10% deposit. Mr. Walters, if you post bail while these charges are pending, you do have a right to be present at all stages of proceedings in your case. But if you did not come back to court, then a warrant would be issued for your arrest. Any bail posted would be forfeited and lost, and you would then face a new felony charge known as bail jumping. And your case could proceed in your absence, meaning you could be tried in your absence, and if convicted, sentenced in your absence as well. Do you understand? There's a written document to that effect. I'll let you take a moment to review that with your attorney.
Thank you, Your Honor.
For the record, the defendant has executed the original Parker warning here in court. The court is now in receipt of the same. The matter is adjourned to March 31st at 9:30 a.m. for a pretrial conference, and I will have you back then, Mr. Walters.
Thank you.
Thank you.
Like from May shop?
Is it Thomas Capezza? Mr. Capezza, I have a number of requests from the news media to cover today's proceedings. Any objection? The court will permit the same. This is the matter of the people against Michael Mashaw, indictment 25035, on for arraignment today. And it is Thomas Capezza, correct, counsel?
Thomas Capezza, Your Honor.
All right.
On behalf of Michael Masher.
Oh, please. You've been retained to represent Michael Mashaw?
Yes, Your Honor.
And sir, that's your name, Michael Mashaw?
Yes, sir.
How old are you, Mr. Mashaw?
47, sir.
Mr. Mashaw, you're here today because the grand jury of Oneida County. Oh, please. You're here today, Mr. Mashaw, because the grand jury of Oneida County returned an indictment against you. You have to be arraigned upon that. And Mr. Fitzpatrick, you may arraign.
Thank you, Your Honor. Mr. Masher, indictment 2025-35, you've been charged by the Oneida County grand jury in count 4 with the crime of manslaughter in the second degree. Mr. Capezza, I ask if you waive a formal reading of said indictment.
Waive a public reading and to please.
Arguing over there?
At this time, Your Honor, I'm going to hand Mr. Capezza a redacted copy of that indictment missing one name, along with our standard pretrial notices, along with a disc containing statements allegedly made by Mr. Mashaw.
You hear
Ask
him
to
yelling?
acknowledge receipt of those.
Acknowledge receipt.
Y'all hear him yelling?
All right. Did I hear correctly? Did you enter a plea?
Excuse me, Your Honor?
You entered a plea. Did I hear you right?
Yes.
All right. A plea of not guilty entered on the defendant's behalf. This matter will be adjourned to March 31st at 9:30 a.m. for a pretrial conference and a setting of a motion schedule. Mr. Fitzpatrick, your thoughts on bail, sir?
Your Honor, I would ask that bail be set consistent with that set on Mr. Fisher and Mr. Walters, and that Mr. Mashaw, if he has a passport, surrender same to Mr. Capezza, and that Mr. Capezza notify the court and special prosecutor when that is done.
Your Honor, we will turn over the passport.
Okay, very good. Thank you. That'll be a condition of any bail set here today. Your thoughts on bail, Mr. Capezza?
Your Honor, we consent to the bail and Mr. Bernardo will provide.
All right, the court's considered the arguments of counsel here this morning, as well as the statutory factors, and bail is then set in the following amounts: $50,000 cash, $100,000 insurance company bail bond, or $500,000 partially secured surety bond with a minimum 10% deposit. We have the bond paperwork. I'll take a look at that, Mr. Bernardo.
You hear that?
We're looking at that now. Thank you. All right, before the court now is bondsman Jay Bernardo. Mr. Bernardo, you should swear to the truth of the content of your bail undertaking and affidavit. Is that correct? Thank you. Did you get his signature, please? Mr. Mashaw, I have before me a proposed bail bond in the amount of $100,000. I understand you're asking to be released on this. Is that correct? You understand what your number one obligation is under this bond? What's that? And on any other date you're required to be in court. You have a right to be present at all stages of proceedings in this case, but if you did not come back to court when required, then a warrant would be issued for your arrest. Any bail you posted, even by way of this bond, that would be forfeited and lost. And you would then face a new felony charge known as bail jumping, and the case could proceed in your absence, meaning you could be tried in your absence, and if convicted, sentenced in your absence as well. You understand that? I've received a written document to that effect entitled Parker Warning. Confirm for me you signed that document here in court after you reviewed it with your attorney. That's it. All right, you'll be released on that bond today. You're due back in this court on March 31st at 9:30 a.m. for a pretrial conference.
Thank you, Your Honor.
That is all. Thank you. Dan.
Not just. Let out back door. Step is not just. Not good. Not good. But you know, it's not right, perhaps. Well, they all go ahead. Please help them. Please help them very much. Please up. It's been about like the guys. Please up. That's it.
Oh my God, y'all. That was out of order. Oh my goodness. Lord have mercy, y'all.
Did you draw any significance from the fact that Deputy Hemaseth was at this one?
No.
How long of a drive is it from where Deputy Hemaseth worked as a law enforcement officer to where you did this autopsy?
I don't know.
Was it your understanding that Deputy Hemaseth was a law enforcement officer in the community that we're in today?
Yes.
How long of a drive is it from here to where you did this autopsy?
I believe it's about 3 hours.
Is it your testimony that you drew no conclusions from the fact that Deputy Hemaseth drove 3 hours to be at this autopsy with you?
No, we have many people visit. Some just come for educational purposes. I encourage it. I think it's important for people who deal with death understand what an autopsy is like.
When you talked with Dr. Hemaseth or Deputy Hemaseth at this deposition, at this autopsy, Dr. Cruz, did he tell you that he was there for educational purposes?
Not that I recall.
I mean, did he tell you he was there to investigate Ms. Mullis's death?
He did.
It was not your understanding at the time of this autopsy he was there to educate himself about your process?
Well, he may have expressed it and I didn't remember. I'm just saying people drive a long ways to see an autopsy pretty regularly.
Had you ever had Deputy Hemaseth at an autopsy with you before this one?
Not that I recall.
During this autopsy, did Deputy Hemaseth tell you his understanding of how Ms. Mullis had been found in terms of the position that she was found with the corn rake in her that led to her getting medical treatment in this case?
Yes.
What did he tell you during the autopsy about that issue, the position of the rake in her body?
I was told that she was essentially face down and the rake was sticking out of her back. I believe at that time, and I've been told subsequently, that 2 tines were said to have been inside her body and 2 tines were outside of her body when she was found.
During the autopsy, did Deputy Hemesath tell you that Ms. Mullis had been found with the corn rake in her back, with the handle of the corn rake facing toward her head?
That does sound familiar. I'd have to go back and look. That's how I envision it when I think back.
And to make sure we're talking about the same thing, we understand that she wasn't found in a sitting up position, but I'm not going to get down on the ground for this purpose. But understanding that sitting here today, I'm not in the position that Deputy Hemesath said she'd been found in. Where would the handle of the corn rake have been relative to my body from your understanding of what Deputy Hemesath was describing?
The way you had just described it, I would envision the rake handle poking up toward the head.
Am I correct that given what Deputy Hemesath was describing to you, he was describing the corn rake handle extending from her back up over her head?
Yes.
And we agree that she wasn't in an upright position, but just to make sure we're talking about the same thing.
Yes.
We're talking about the corn rake coming up this way, correct?
Yes.
All right. As you sit here, well, let me ask you this. At the time of your deposition in 2023, was that your understanding of how she had been found?
Yes.
Was that your understanding at the time of your autopsy?
Yes.
As of the time of your deposition in 2023, had anyone ever told you that that was not how she was found?
Not that I recall.
Did you base your opinions in this case on an understanding that at the time that Ms. Mullis was found, the handle of the corn rake was extending up over her head?
No.
And when you say no, can you explain to me what you mean by that?
How someone said they found the rake, the position of the handle, the position of her body, the rake was removed from her body. If I saw the corn rake like that, then maybe I could take it into consideration, but a simple description such as that had no bearing on my determination and was unnecessary to make the determination of homicide.
Why was it unnecessary for your ability to determine whether this was a homicide to try to determine what position the rake was in at the time Ms. Mullis was found?
Ms. Mullis was impaled with the corn rake, and how the corn rake ended up in her doesn't really change the fact that it's homicide.
And I want to make sure that I've asked my question in a clear way. And I'm going to ask with the court's permission, because I don't remember exactly how I worded it, is it possible for the court reporter to read the question back, Your Honor?
It is.
Thank you.
Why was it unnecessary for your ability to determine whether this was a homicide, to try to determine what position the rake was in at the time Ms. Mullis was found?
Was that your understanding of my question when you gave the answer you just gave?
Yes.
Am I correct that it was not important to you to understand the position that the corn rake was in at the time Ms. Mullis was found?
I would need more information to consider it, such as what injuries were associated with that corn rake in the position in which it were found, if you follow.
Well, at the time of your autopsy, what you were doing was looking at her injuries and trying to understand what those injuries were. Is that correct?
Well, I could tell what her injuries were.
Was the purpose of your autopsy to assess what her injuries were?
Yes.
And so when you say that you would need more information, would it have assisted your analysis of whether or not Ms. Mullis, the manner of Ms. Mullis's death was a homicide, to understand the position that the rake was in relative to her body when she was found with the rake in her?
No.
We've been talking about your conversation with Deputy Hemesath at the time of the autopsy. And during your conversation with Deputy Hemesath during the autopsy, did you discuss with him the possibility of this being, of Ms. Mullis's injuries being the result of a fall?
We did discuss how they were not the result of a fall.
Well, during the autopsy itself, before you had finished the autopsy, did you tell Deputy Hemesath that it was your opinion that the injuries that you observed during the autopsy were not the result of a fall?
I told him definitively at the end, and he had asked, and we discussed that they were allegedly from a fall, and he asked me, could they be from a fall? And I said no.
Was it your opinion that these injuries weren't from a fall even before you finished looking at Ms. Mullis's body?
It was determined at the end of the autopsy. Much of the examination is that external examination that begins the entire process. So I had a pretty clear idea before the internal examination began, and did not issue a final opinion until the end. But I was certain at the beginning that it was a homicide, and everything else within my autopsy supported that. I remained open throughout and found no evidence to the contrary.
Did you determine that Ms. Mullis's injuries were a homicide before you did your internal examination of her body?
Homicide was the manner of choice at that time. However, as I said, I remained open and found no evidence to the contrary.
While you were conducting the autopsy with Deputy Hemesath present, did he ask you if he could bring the corn rake into the autopsy to assist in an analysis of this case?
He asked if he could bring the corn rake closer to Ms. Mullis and her clothing items. I said I preferred to keep them separate. The corn rake itself was within the autopsy suite, which is rather large for the purpose of photographing it. The corn rake did not come in contact with Ms. Mullis during the autopsy.
During the autopsy, did you photograph the corn rake?
Yes.
During the autopsy, did you compare the corn rake directly with the injuries on Ms. Mullis's body?
I examined each separately. As I had said, I did not put them close together, but I examined them separately and within a very small time period.
How far apart were the tines on the corn rake?
I would have to check my notes. I don't quite remember.
Which notes would you like to check to answer that question?
I guess I would have to go back at the photographs because I did not put that in my actual written notes or in my autopsy report.
Was it important to your analysis to know how far apart the tines of the corn rake were?
It was information to consider. Like I said, there had been no information to suggest that anything other than the corn rake caused her injuries. There are some inherent difficulties in comparing a fixed object with the human body, which is malleable and can contort into different positions. So taking straight measurements from an object and comparing them directly with the body is fraught with issues. But measurements such as that are important just to have every bit of evidence possible.
Is there a reason, if it was important for you to have those measurements, that you didn't document them in your notes or your report?
They were documented with photographs, and I can't recall why I didn't simply write it down.
You talked about, during your autopsy, conducting both an internal examination and an external examination of Ms. Mullis's body. And I want to ask you, just as to the external examination, you examined, well, during the autopsy, did you examine her face and her head?
Yes.
Did you examine the front of her chest?
Yes.
Did you examine her hands?
Yes.
Did you examine her knees?
Yes.
And I think you told us a minute ago that you did examine, you had the clothing that she'd been wearing accessible to you at the autopsy as well.
Yes.
What was your understanding of what clothing she'd been wearing that would have covered the top half of her body at the time that she experienced these injuries?
I know on the outer layer she was wearing a thick jacket, and I believe she had 2 additional layers of clothing on top.
At the time that you conducted the autopsy, did you look at Ms. Mullis's clothing for any holes?
Yes.
Why did you do that?
The holes were actually quite obvious when we photographed them. It's within our standard procedure to photograph clothing as it is received. So I make note of everything I see.
How many holes did you see on Ms. Mullis's coat at autopsy?
I saw multiple holes. I did not count them.
Were the holes in her clothing important information to help you determine what the cause and manner of her death were?
No.
Did you photograph her clothing during the autopsy with the holes that you'd observed in the clothing marked?
Yes.
Did you take, well, I'm actually going to show you, at this moment, Your Honor, I'm going to show the witness exhibit 524. Is that being displayed?
Yes.
She has it now, yes. You've been shown, Dr. Cruz, what's been marked as exhibit 524. Do you recognize this exhibit?
Yes.
What is it?
It's an autopsy photograph. This is of Ms. Mullis's jacket. It has a ruler with our state medical examiner number on it and a number of arrows that point to defects in the clothing.
Does exhibit 24 accurately reflect the holes that you saw in the jacket at autopsy?
It accurately reflects what I saw at autopsy, yes.
Well, did you or your assistant put 4 large arrows on the 4 holes that you saw in the jacket to document those holes in this photograph?
Yes, my assistant did.
Was this photograph the only documentation of the holes that you saw? Let me ask this question again. Was this photograph, exhibit 524, the only documentation that you made of the holes in Ms. Mullis's jacket at autopsy?
There are other photographs. I can't recall if they have arrows or not.
Is it your testimony that there are, well, let me ask you this. Are there any other photographs with arrows marking the holes that you observed at autopsy?
I just said I don't recall.
were talking about your conversation with Deputy Hemasath for a minute. And I believe it was your testimony that it did not matter to you what position the rake was in at the time Ms. Mullis was found in terms of the ultimate cause and manner of death determinations that you made about Ms. Mullis's death. Is that right?
What someone says in terms of the position, yes. I mean, that's taking someone's description at face value. So no, I did not take it into consideration and did not need to.
Well, did the information about how the rake was found in her body help you to make it clear what caused the injuries?
The fact that a rake was found in her body was helpful, yes.
Did it help you to determine which injuries Ms. Mullis experienced in what order?
No.
Did it help you to determine, well, is it your testimony today that the fact that the rake was in her body in a certain way was not important to your assessment of the cause and manner of her death?
The fact that someone says they found the rake in a certain position was not something I considered or needed to consider.
At the conclusion of your autopsy, did you feel confident that Ms. Mullis's death was a homicide?
Yes.
If you had not been confident at that time that Ms. Mullis's death was a homicide, what would have been the appropriate finding in your case?
I would have pended the case for further review, investigative materials, etc.
And you did not pen the case at the conclusion of the autopsy?
Officially, I did on paper, but verbally, no, I did not. It was determined to be a homicide.
Was the reason that you penned the case on paper because law enforcement asked you to do that so that they could continue an investigation?
I don't have a recollection of if I was asked to. It's something I would have offered to do. It's pretty standard in our practice. We will withhold cause and manner of death so law enforcement can continue with their investigation so it doesn't jeopardize their investigation.
At the conclusion of this autopsy, was whatever was on paper, in your heart, this was not a pending investigation in terms of the cause and manner of her death. Is that right?
Yeah, in my brain, it was not pending.
All right. You did have one, well, let me ask you this. Did you have the toxicology request that was still outstanding at the conclusion of the autopsy?
Yes.
What type of toxicology request did you make at the end of this autopsy?
I ordered what we call a basic panel. It looks at drugs of abuse and alcohol.
Does this basic panel look for prescription medications beyond drugs of abuse?
No.
For Ms. Mullis's autopsy, could you have submitted a request for a toxicology panel that covered prescription medications other than drugs of abuse?
Yes, I could have.
Is that something you did?
No, I did not.
You told me a minute ago that you were open to, that you, in your general practice, are open to other information about your cases other than what you see and observe at autopsy. Is that right?
Yes.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any context about where exactly her body had been found?
No.
Did you want any context at the time you determined this was a homicide about where on the Mullis property she had been found?
No.
Did you want any context at the time you determined this was a homicide about what the materials were, what the floor was made of in the area where she was found?
Out of all the information you provided, that would be the most interesting because I do think she She did sustain blunt force injuries that could be related to hitting the ground. So I think that information would be useful, yes. But it would not change my manner. Sorry.
At the conclusion of your autopsy, how did you know that it wouldn't change your opinion what surface she'd been found on if you didn't know what surface she was found on?
She was impaled in the back with a corn rake, so what she was standing on didn't really make a difference. But it's important to be able to understand all different sorts of wound patterns. And in addition to the injuries on her back that caused her death, she had some blunt force injuries.
Was it Well, as to the blunt force injuries, at the time that you determined that Ms. Mullis's death was a homicide, did you know what had caused any of the injuries that you say were blunt force injuries on her body?
No blunt force. None of them had a pattern that could tell me definitively where they came from.
Is it true then that you did not need to understand what those blunt force injuries were in order to determine that Ms. Mullis's death was a homicide?
I did not need them, no.
I mean, is it true that those blunt force injuries then were not relevant to deciding whether or not Ms. Mullis was the victim of a homicide?
They were supportive, but not absolutely necessary for that determination, no.
Dr. Cruz, how could they be supportive if you didn't even know what caused them?
They were supportive, as I had said earlier. She sustained a number of puncture wounds to her back, suggested to be from a fall, which would make the manner of death an accident, which is seemingly the only other option than homicide. If someone falls backwards, they don't get injuries to the front of them. So that supported that she was impaled with the corn rake and did not fall backwards on it.
Is that the only reason in your mind that determining what caused the blunt force injuries wouldn't be relevant to your determination about whether or not this was a homicide?
I think relevant is misleading. It's important to document everything you see and not be dismissive of it. So I take my findings and I do my best to interpret them appropriately. Seeing an injury and then getting additional information as to what could have caused it is always helpful and important for every pathologist to take that into consideration. I did not need them to determine that her cause of death was due to the sharp force injuries of her back. Her death was not due to blunt force injuries.
Was it possible in your mind at the time that you completed Ms. Mullis's autopsy that there could be an explanation for every single one of the blunt force injuries that you observed on her body that would explain that those injuries were caused by her everyday life or an accidental source or something that did not have to do with her being struck by, in your mind, struck by a corn rake?
Are you saying there are explanations like that for them?
I'm asking you, did you consider that possibility at the time you determined this was a homicide?
Blunt force injuries are difficult to interpret, so it's always important to consider that they could have come earlier in the day and may not have been associated with the injuries that caused someone's death. The sheer number of Ms. Mullis's injuries and the nature of them is highly suggestive that at least most of them are associated with her death.
Is that because of, in your mind, the number of other things you observed?
I've performed many autopsies, and the number of her injuries was substantial. And I do not think they were incurred during the course of her everyday life.
Well, at the time that you determined that Ms. Mullis's death was a homicide, did you take any steps to learn what the cause of any of the other, what you say were blunt force injuries on her body were?
As I stated, blunt force injuries can be difficult. None of them had a clear pattern to them. So you could take steps to postulate as to how they happened, but there's no way to know for sure. And to say you know exactly for sure how they happened is incorrect.
And Dr. Cruz, isn't it true you were taking steps to postulate how they happened by postulating that in your mind, because of the number of them, they must have been associated with her death?
I'm not saying exactly how they occurred, which is what you asked me.
But it was your testimony that because of the number of them, it was unlikely that they were injuries that occurred in the course of her everyday life. Wasn't that your testimony?
Yes.
So you were postulating that based on the number of them, even though you didn't know what they were caused by, they were related to her death.
That they were most likely related to her death, at least most of them.
So isn't it true that you were postulating what those injuries were without really having any understanding of why they were there?
I do not know exactly what caused them. However, in my expertise, my medical opinion, those are not due to everyday life. And that's an important determination we need to make as forensic pathologists, because we often get cases, more often than not, when there's concern that someone has a number of injuries, then law enforcement may think that their death may be due to an injury. And we then determine if those injuries could be due to normal everyday life. That's something that's standard to my practice, and I feel very comfortable doing that.
Did you have any way to distinguish at the time of Ms. Mullis's autopsy whether what you say were blunt force injuries on her body were injuries that she experienced in a fall versus from some other source?
Like I said, you can't say exactly what it is. It could be from a fall, absolutely. Striking objects while falling, striking the ground, absolutely.
And if the blunt force injuries that you say you observed on her body during the autopsy are consistent with a fall, then how could any of those injuries be supportive of the idea that Ms. Mullis's death was a homicide?
The blunt force injuries are on the opposite side of her body to the other injuries. So either she fell forward or backward, you can pick one.
Is it true that at the time of Ms. Mullis's autopsy, that because you could not envision a circumstance in which Ms. Mullis sustained these injuries, other than someone impaling her with the corn rake, that is the reason you determined that this was a homicide?
There is no other way. Yes.
And that's your opinion based on the autopsy that you conducted and your conversations with Deputy Hemasat?
I'm not sure how my conversations with him helped me come to that conclusion. Without speaking to him, I would have come to that same conclusion at autopsy.
That would have been your conclusion based solely on what you observed at autopsy?
Yes.
And that's because you did not take any steps to learn any context about, for instance, what the surface of the floor was in the area where she was found?
I was able to make that determination without that information at that time, yes.
And you didn't seek that information out?
No, not at that time, no.
Did you need to know at the time that you determined that Ms. Mullis's death was a homicide, whether she had been found with her face resting on a surface for some period of time?
I was aware that her face was on the ground, and I am aware you have someone saying that her face was resting on the floor for such a period of time. She sustained a very large abraded contusion on her jaw. I don't think that's an appropriate explanation of that injury, especially given that she has additional injuries to the left side of her head, such as bruising to her left ear, bruising behind her left ear. But if that's what another forensic pathologist wants to say, then it still doesn't change my opinion.
Well, Dr. Cruz, that wasn't my question, was it? I mean, my question was whether at the time you determined that her death was a homicide, whether you had information at that point about whether her face had been resting on a surface.
I don't recall. I know that I was told that she was prone, so face down, so her face could have been resting. It's a possibility.
At the time you made your determinations, did you take any steps to learn that?
Where her face was?
Yes.
Not that I recall.
At the time that you determined that Ms. Mullis's death was a homicide, did you know where she had been injured?
I'm sorry, could you repeat that?
Sure. At the time that you determined Ms. Mullis's death was a homicide, did you know where it was that she had been injured?
Meaning, location?
Not the location on her body, but the location in the world.
Yeah, I'm very body focused, if you haven't noticed. I was told she was injured on a farm in a shed.
Well, you were deposed in this case, isn't that right?
I was deposed twice.
You were deposed in this case in 2023?
Yes.
And isn't it, do you recall being deposed in this case?
Yes.
Did you Did you testify at your deposition in 2023 that you did not know where it was that she had experienced these injuries?
Correct.
So at the time you determined that her death was a homicide, you did not know where it was that she'd been injured?
No, I was told where she was found. And all that's just information from other people. I have absolutely no idea where she was injured.
At the conclusion of your autopsy in this case, did you certify the death certificate for Ms. Mullis?
I waited. That's that pending cause and manner. I eventually did certify it.
And I understand, I was not intending to imply that you did that immediately, but at some point after you completed the autopsy, did you certify the death certificate for Ms. Mullis?
Yes.
What does it mean to certify someone's death certificate?
A death certificate is a document that has a number of bits of information about a person. The part that I'm responsible for as the medical certifier include the cause of death, the manner of death, how injury occurred, and some other little bits of information. So to certify the death certificate means to place that information into an electronic record, and then I electronically sign it.
By certifying a death certificate, are you certifying that the information on the death certificate is accurate?
Yes.
I'm going to show you what's been marked as Exhibit 354. Your Honor, we're going to show the witness what's been marked as Exhibit 354, and I'll just make a record that there is some personal identifying information on this record retrieved redacted, but otherwise this is a true and accurate copy of Exhibit 354.
Okay, the record will reflect that.
Are you seeing Exhibit 354?
Yes.
What is Exhibit 354?
This is Amy Lynn Mullis's death certificate.
Do you see that her birth date and her social security number are redacted?
I do see that, yes.
Other than those redactions, is Exhibit 354 a true and accurate copy of the death certificate that you certified as to Ms. Mullis's death?
That portion that I described that I certify, I can say yes. The decedent information portion is the responsibility of the funeral home. So I'm not necessarily comfortable saying that's true. I don't know where she lived.
Other than the decedent information section, did you complete the remainder of this death certificate?
Most of it, yes. Not that funeral home portion at the bottom, but really that central area.
Understood. Did you complete the portion of this death certificate that provides a medical cause of death?
Yes.
And what did you certify as the medical cause of death for Ms. Mullis?
Sharp force injuries of torso.
Is it your opinion in this case that the injuries that Ms. Mullis had on her torso were sharp force injuries?
Yes.
And this death certificate does this death certificate provide a space to explain what the injuries that you identify as the cause of death are due to or as a consequence of?
Yes, that's what it said. In this case, there really wouldn't be anything appropriate to put underneath that.
And why is that?
So sharp force injuries of torso are essentially, well, there are two components of the cause of death on a death certificate. There's the immediate cause of death, whatever condition, injury that ultimately led someone to die right away. That can be due to something else, which is called the underlying cause of death. That immediate cause of death sometimes can be so specific, it really doesn't belong on the death certificate, because ultimately a death certificate is for vital statistics purposes, tracking diseases, injury trends. So that underlying cause of death is really the most important, which is what I put. So the sharp force injuries of torso is that underlying cause of death. If you wanted to put something above it into immediate cause of death, like pneumothorax, something along those lines, you could. But in my opinion, in this case, the sharp force injuries of torso is perfectly sufficient for cause of death.
And did you identify in this certificate the immediate cause of death as you just described?
I did not. And in this case, with an injury that happens quickly like this, one could argue you're getting into mechanism of death territory, which we are instructed not to do by the CDC. So to me, her death was sharp force injuries of torso.
Did you include on this death certificate what the place of her injury was?
Yes.
And what did you say on Ms. Mullis's death certificate the place of her injury was?
Farm building.
Isn't it true that at the time, that by your testimony, at the time you determined the cause and manner of her death, you did not know in your mind where she'd been injured?
Yes.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any context about what Ms. Mullis had been doing earlier that day?
Want is an interesting word. I do like having information about the circumstances surrounding the death. So sure, I would want more information such as that.
At the time you determined that Ms. Mullis's death was a homicide, did you have any information about what Ms. Mullis had been doing earlier in the day that she was injured?
I believe I did. I believe she was working on the farm in some capacity.
Where did you get information about her working on the farm at the time that you determined that Ms. Mullis's death was a homicide?
That would be from law enforcement.
Isn't it true that that's not information you learned until after you had determined that this was a homicide?
I suppose I can't recall clearly. We received a lot of information in a short period of time, so it's definitely possible I learned it after. But it's a pretty simple bit of information. I don't think it would take too much digging to get that.
Well, in this case, Dr. Cruz, did you receive a lot of information in a short period of time before you determined that Ms. Mullis's death was a homicide?
I guess it's your opinion is that a lot of information. I had information about the circumstances surrounding her death. I didn't have finalized law enforcement reports. And as we established, I can't recall if I had her medical records or not. So I didn't have what one would consider a ton of information, but I didn't need it.
The only information you had at the time you determined this was a homicide was information that you saw at autopsy and that you got from talking with Deputy Hemosath and with Dr. Thompson, correct?
As far as I recall, yes.
And that was not a lot of information.
I suppose that's your opinion.
Well, I'm asking if, in your opinion, was it a lot of information?
Judge's been asking the answer, and she's also being argumentative at this point.
Sustained.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any information about the prescription medications that Ms. Mullis was taking?
No, but I had it. Oh, I'm sorry, after the autopsy, I did get that information.
And to be clear, I'm asking about at the time you determined this was a homicide. At that time, you did not know anything about prescription medications that she was taking?
Not that I recall, no.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any information about what emergency responders had observed when they provided her with medical aid?
I do want information about what emergency responders saw, and very much so about what they do, or what they did as part of their resuscitative efforts.
You testified a moment ago about being concerned in your testimony today about injuries that were on the front of Ms. Mullis's body. You know now that Ms. Mullis had resuscitative efforts on her way to the hospital, is that right?
Yes.
Did those resuscitative efforts include her receiving CPR?
Yes.
And did those resuscitative efforts include the use of something called a Lucas device?
Yes.
Can CPR and the use of a Lucas device bruise someone's chest?
Yes.
Is it common for those actions to bruise someone's chest?
Bruise or abrade the chest, yes.
And so the blunt force any blunt force injuries that you observed on Ms. Mullis's chest that were in the area where CPR is performed, are those injuries that you would expect to be associated with CPR?
It can be difficult if someone has injuries to begin with and CPR is performed in that same area. But I think it's reasonable to say that at least some of the injuries could be from CPR.
Well, in this particular case, would you as a forensic pathologist assume that injuries in that area would be connected with CPR?
I think it's most likely. And I did so. She had a sternal fracture that I determined to be related to CPR.
And you mentioned this a moment ago. At the time that you determined that Ms. Mullis's death was a homicide, did you have any of her medical records from Regional Medical Center?
I do not recall.
Do you remember what day of the week you did Ms. Mullis's autopsy?
Yes.
What day of the week was it?
Monday.
And what day of the week was Ms. Mullis brought into Regional Medical Center?
It was a Saturday.
Isn't it true that you did not get Ms. Mullis's medical records until after you conducted the autopsy in this case?
I think that's the most likely scenario.
At the time you determined that Ms. Mullis's death was a homicide, had you talked with any biomechanical expert?
No.
At the time that you determined Ms. Mullis's death was a homicide, had you talked with any incident reconstruction expert?
No.
At the time that you determined that Ms. Mullis's death was a homicide, did you have an understanding of the angle of the wound paths on Ms. Mullis's torso?
Yes, I determined, well, the direction of the wound paths within the body. I did not have a specific angle.
At the time you determined that Ms. Mullis's death was a homicide, did you want to figure out the specific angle of the wound paths?
No.
At the time that you determined that Ms. Mullis's death was a homicide, did you have in your mind of exactly how the corn rake entered her body?
She was impaled with it by another person.
And I understand that your opinion is that she was impaled by another person, but at the time you determined this was a homicide, did you have any understanding of how she was impaled?
Could you be more specific?
Sure. Did you have an understanding of whether the corn rake was swung into her body?
I did not, no.
Did you have an understanding of whether the corn rake was pushed into her body?
No.
Did you have any understanding of whether the corn rake entered her body in some other way by a person, in your opinion, causing it to enter her body?
It could have been swung, pushed, kicked. Someone else impaled her in the back with the corn rake multiple times.
Was it important to you at the time you determined this was a homicide to try to determine which of those routes this was?
That's not something I could do.
At the time you determined this was a homicide, did you want to understand why there had been blood found on Ms. Mullis's hand?
Did I? No.
At the time you determined this was a homicide, did you want to figure out why there was blood on the handle of the corn rake?
Want, again, is a hard word. I was aware that there was blood on the rake. I was told that she was found with a rake in her. To me, it supports the implement that caused her injuries. So I already knew all that at autopsy.
At the time that you determined Ms. Mullis's death was a homicide, did you want to understand if there was some connection between the blood on the rake and the blood on her hand?
The blood on her hand has so many potential sources. As you yourself indicated, she received CPR and pretty lengthy CPR. I just don't know the nature of that blood, so to try and connect those two would be inappropriate in my opinion.
Did you take any steps to learn the nature of that blood?
As I said, given all the events that followed Ms. Mullis being found, I don't think anyone could reasonably determine where that blood came from.
And you mentioned earlier that there's an issue in connection with a death where you have a cause and a manner and then also a mechanism. Is that right?
Yes.
What is a mechanism of death?
Mechanism, it's a really specific sort of derangement within the body that causes someone to die. It's discouraged in terms of putting it on the death certificate. Some examples that we see quite often are cardiac arrest. Someone's heart stops beating. Respiratory arrest. Someone stops breathing. Sure, those are ways people die, but really not a cause of death. What made their heart stop? What made them stop breathing? So the mechanism is that final thing of how you actually die, but a cause of death is what led to ultimately to that death.
And I understand your testimony that you did not need to list the mechanism of death on the death certificate, but at the time that you determined that Ms. Mullis's death was a homicide, did you know what the mechanism of her death was?
Yes.
Did you identify the mechanism of her death in your autopsy report?
No.
Did you identify the mechanism of her death in any of the reports that you prepared about your autopsy?
I did not say it explicitly. The description of her wounds from a medical standpoint, it's quite clear, but I did not explicitly state it, no.
What did you testify at Mr. Mullis's criminal trial in 2019 was the cause of Ms. Mullis's death?
Sharp force injuries of torso.
And what did you testify at his criminal trial was the mechanism of Ms. Mullis's death?
As far as I recall, it's the chest cavity being compromised by the corn rake tines entering into it, which caused entry of air and some blood leakage into the cavity, albeit not that much. She also had direct injury to her organs.
In that testimony in Mr. Mullis's criminal trial, did you identify which side of her chest had air entering into it as you just described?
Looking back, I believe I had only said the right side, but obviously the corn rake tines also entered into the left side of the chest. That would introduce air into both sides of the chest, some blood, and then only on the right side did she have actual injury to organs, and then on the right side of the abdomen as well.
Have you looked back at your criminal trial testimony since the time of the trial?
Yes.
Is your testimony at Mr. Mullis's criminal trial about the mechanism of her death wrong?
It isn't comprehensive, I would say. I was focused on the direct injuries to organs on the right side of the body. I described how air enters into the chest cavities. So I said right, when in reality it should have been both chest cavities. I did explain quite thoroughly how there was injury to the left side of the chest as well. So it was implied, but not stated explicitly.
Was it important to you in testifying at Mr. Mullis's criminal trial to be correct about the mechanism of Ms. Mullis's death?
I would like to have been, yes.
Do you agree with me that your description, even by your account today, of what the mechanism of her death was incomplete?
I'd have to look at my wording if I said this is the exact mechanism of death to see if it was truly incomplete or if I was just describing part of the way she died.
And I'd like to show this. The criminal trial testimony for Mr. Mullis's criminal trial, volume 3, is exhibit 1 moment, Your Honor. I'm sorry, what is it? Thank you so much. 349. And I'm going to refer the witness to page 98. 98. Tell me when that's there. And let me ask you, would it refresh your memory to look at your trial testimony to recall exactly what you said?
I'd like that, yes, thank you.
I'm gonna, if the witness could read page 98, I know that's not up quite yet, and I'm gonna direct the witness to line 13 of page 98 through line 3 of page 99. Here, I have a paper copy if that would assist us in moving forward, that I'm happy to show the witness.
I think we have it on the
All
screen.
right, thank you, Your Honor.
Yep.
Would you like me to read it out loud? I'm sorry.
No, just to yourself. And I'm directing you to page 98, line 13 to page 99, line 3.
We can go to the next page for me, or
Nicole, can you scroll down?
just that one paragraph.
Well, looking at the piece of testimony that I just directed you to, did that refresh your memory about what you testified to at Mr. Mullis' criminal trial about the mechanism of Ms. Mullis' death?
Yes.
All right. And I think the question I asked you before you reviewed that testimony was whether in your testimony at his criminal trial, you testified about which side of her chest the issue with air coming into the chest cavity was on.
Could you go back to the previous page? I'm sorry, so I can look at it again. Thank you. Yep. I see reading it now, and I think I was swayed a bit by reading your expert's opinion. It says that I said it only went into the right chest cavity, that I simply say it goes into her chest cavity singular, but I don't say what side. But I do accurately describe what's called pneumothorax, which is air entering into your chest and causes issues with your vital organs there. Something that your expert also agreed was appropriate and accurate.
Well, your testimony at Mr. Mullis' criminal trial was that the issues with pressure in the chest were on the right side of Ms. Mullis' chest, right?
I said that she had injuries to her right lung, which caused leakage of blood. I was not specific as to what side the air came into, but I do say chest cavity singular, so I suppose it's up to interpretation.
Isn't it true that at the time of your autopsy in this case, you actually didn't know which side of Ms. Mullis' chest had what you describe as a pneumothorax?
That's something that's difficult to identify at autopsy. Upon review of her medical records, it's clear that she had a large pneumothorax or air in her left chest cavity. It's also clear from my autopsy and the medical records that she had a right-sided chest tube placed. Notes indicate that air was released from that right-sided chest tube, meaning that she had air in both of her chest cavities, which simply makes sense.
Right, and does the fact that you didn't appreciate a left pneumothorax at autopsy, which I understand your testimony is you might not have appreciated that at autopsy.
Mm-hmm.
I mean, does that suggest to you that you hadn't looked at the medical records from the hospital that would have allowed you to identify that there was a left side tension pneumothorax?
I did not review the medical records at that time. I'm not sure what difference it actually makes from a medical doctor standpoint. Her having pneumothorax should have happened. So if you asked me without even seeing the body, gave me that scenario, I would tell you that's what happened. And that was confirmed with the medical records. She died because she was impaled with the corn rake and the effects of having that corn rake inside of her body, which includes air in the chest cavities.
Was the left side tension pneumothorax the actual cause of Ms. Mullis's death?
The x-ray that identified the left-sided pneumothorax was taken after that right-sided chest tube was placed. The medical records indicate that it was pretty significant. So if she had left-sided pneumothorax alone, absolutely. But to say that it was the only thing that contributed when she also had right-sided pneumothorax, she also had direct injury to her lungs and to her liver, I think would be insufficient.
Well, if Ms. Mullis hadn't had the left-sided pneumothorax and only had the injuries to the right side, those were injuries that she could have survived. Is that right?
She could have survived the left-sided pneumothorax as well. Prompt medical therapy can treat pneumothoraces. It can treat injury, direct injury to lungs. I don't see a difference.
Your testimony at Mr. Mullis's criminal trial suggested that there was bleeding in Ms. Mullis's chest as part of the mechanism of her death. Did you see that in what you just reviewed?
I did.
Was there actually very much blood in Ms. Mullis's chest at the time of your autopsy?
No.
Is it correct that bleeding into her chest cavity was not really a part of the mechanism of her death?
If you were to have that alone, no, I don't think that would have caused her death.
And I want to make sure I understand your testimony. Is it your testimony that whether or not she had the pneumothorax on the left or the right side of her chest wasn't important in your assessment of whether or not this was a homicide?
No, those are consequences of being impaled with the corn rake. It's a homicide because she was impaled in the back. Those are things that happen from being impaled in the back by another person, which made it a homicide. What happens to the body doesn't make a difference. Someone gets shot in the head, and I talk about bleeding on the brain, really doesn't make sense. They were shot in the head.
Did you know at the time of her autopsy which injuries Ms. Mullis experienced first? The injuries on the left side of her back or the right?
No.
And did you know how much time, if any, passed between the time that she experienced any of these injuries on her back?
I do not know, no.
Would it have been important to your analysis to have known that?
How would I have known that?
Well, that's my question for you. Did you have a way to determine that?
I wasn't there, so I wouldn't know.
Were you open in your investigation to receiving information that would have helped you understand that?
Who would provide that information to me?
At the time that you determined Ms. Mullis's death was a homicide, could you think of a single person who could have assisted you in understanding that?
Other than the person who impaled her, no. And it really doesn't make a difference. Someone impaled her in the back with a corn rake.
I mean, does that question that I'm asking you today seem silly to you?
To ask if there was a time period between someone impaled her in the back once with a corn rake and then again with the corn rake again doesn't make sense or really matter. She was impaled in the back with a corn rake by another person. Whether they took a beat before they did it again doesn't make a difference to me.
If Ms. Mullis experienced the pneumothorax, the tension pneumothorax on the left side of her chest first, how quickly would that have caused her death?
Something like that would not be immediately fatal. She very well could have had many minutes before she lost consciousness and ultimately died. It's hard to know for sure, but minutes likely went by.
Would Ms. Mullis still have been breathing?
Yes.
Would Ms. Mullis still have been able to move?
Most likely, yes.
would the pneumothorax have led to a situation where air entered Miss Mullis's, where liquid developed in Miss Mullis's lungs?
Oh, we're fluid.
Fluid,
Then
thank
build
you.
up, but yes, yes.
You're the doctor,
absolutely.
so fluid
Yes,
is a better word.
No
I appreciate
problem.
that.
Yep.
Would that have led to a situation where Miss Mullis was breathing out foamy fluid out of her mouth and potentially her nose?
Yes.
Were there any errors in the autopsy report that you created about Miss Mullis's death?
Yes, I do have a typo.
What typo is in there?
It's an unfortunate one. It's in the opinion section. When I state wound direction, I say from front to back instead of back to front. It's the danger of repeating something over and over again. It's the only typo I could find.
And when you say that's an unfortunate typo, what do you mean?
Well, it's important to determine whether it's front to back or back to front. It's a fact and obvious, but should have been written appropriately.
Is it true that that's not a typo that you caught when you finalized this report?
No.
And did anyone else who reviewed your report catch that typo?
No.
Have you issued a corrected autopsy report at any point about Miss Mullis's case?
No.
After you determined that Miss Mullis's death was a homicide, did you continue talking with investigators who were investigating Miss Mullis's death?
Yes.
And I think it was your testimony earlier that you did tell those investigators your opinion on the cause and manner of her death before your autopsy report was finalized. Is that right?
Yes.
Did you talk with investigators from DCI after a couple of days after your autopsy, after you conducted the autopsy on Miss Mullis's body?
Yes.
Why did you talk with investigators? Well, let me ask you this. Did you talk with them on November 14th of 2018?
Yes.
Did those investigators ask to have a briefing with you about the autopsy?
They asked to discuss the autopsy, my findings, yes.
And you did you talk with them on that day?
Yes.
Did those investigators give you information about their investigation at that briefing on November 14th of 2018?
Yes.
Did they tell you at that briefing on November 14th of 2018 that they believed that Mr. Mullis had a motive to hurt his wife because of what they told you was affairs?
Yes.
And did you know why on November 14th of 2018 they were telling you that?
You would have to ask them, but it's not unusual information to receive.
Is it not unusual because you're part of the law enforcement investigation into people's death?
I'm not part of it. People often like to share what they've learned. I had already determined cause and manner of death, so you'd have to ask him why he wanted to share it.
Did you tell investigators on that call on November 14th of 2018 generally what the conclusions of your autopsy were?
I believe so, yes.
And what did you tell investigators on November 14th of 2018 about, in your view, how many times it was that Ms. Mullis had been impaled on this corn rake?
At least 2 times. Given the orientation of the wounds on her back, there's a high likelihood that it was 3 times.
Did you tell them in this briefing that it was possibly, or that there was a high likelihood that it was 3 times?
I believe so, and I maintain that.
Do you agree with me that your case log notes don't reflect that you told them that there was a high likelihood that it was 3 times?
That's my investigator's case log notes, and I'd have to look at it. But if it doesn't say it, it doesn't say it.
Well, don't you participate in maintaining those case log notes as well?
One person types them. So say there are multiple people who are a part of a meeting or a discussion, one person will type up the notes.
Do you check those notes?
I read them, but I do not edit them. I don't want to alter them. They're as another person remembered them.
Do you initial those notes?
No.
Oh,
I'm sorry. Just to be clear, I do not initial notes. I do not write.
I want to show the witness at this point, Exhibit 573. And I'll just say that we've made some slight modifications to the original photograph of the 573 just for purposes of privacy for this hearing. Is that Exhibit 573 in front of you?
Yes, that's what it says.
Is Exhibit 573 a true and accurate photograph of the condition of Ms. Mullis's back during the autopsy that you conducted on November 12th of 2018?
It appears so. You said you altered it in some way, but it seems appropriate.
And I'll just represent to you that it's cropped a little bit.
Okay. Yes.
From your original photograph.
It seems fine to me.
Okay. You mentioned, we'll come back to Exhibit 573, so you can remove that, Nicole. During the briefing that you had with the investigators on November 14th of 2018, did you talk with them about other defects that you noticed on Ms. Mullis's body aside from the 6 wounds that we've been talking about that were on her back?
I noted other injuries, yes.
And you've talked a little bit in your testimony about some of the other injuries that you observed and your assessment of them, but I want to ask you a couple of questions about that. I mean, in your briefing with investigators on November 4th of 2018, did you talk to them about this injury you've referenced to the left side of Ms. Mullis's chin?
You say this. I'm not looking at anything, to be clear. Okay.
Understood.
And injury to the left side of her chin. I most likely did, yes.
I mean, you've referenced in your testimony an injury to the left side of Ms. Mullis's chin. And when I say this injury, I'm talking about the injury you previously identified in your testimony.
Yes.
Did you talk to the investigators about that injury at this meeting?
I most likely did.
Well, did you tell them that that injury did not have any associated injury to the inside of Ms. Mullis's mouth at this conversation on November 14th of 2018?
I know you're referencing notes that I did not make. She also had an injury to her lip, so I don't know if inside of the lip injuries were relating to a lip injury. To say that there were injuries to the side of her chin and then talk about the inside of her lips seems to be a little bit of a jump.
Well, I don't want you to make any.
I don't recall exactly what I said, and I don't recall exactly how they were written in those notes by another person.
I don't want you to make any assumptions about what I'm referencing. So let me be a little more straightforward. When you observed Ms. Mullis's face at autopsy, did you note in your autopsy report any injuries to the inside of her mouth?
No.
I mean, she didn't have any scrapes on the inside of her cheeks, did she?
Not that I saw, no.
Did she have any abrasions or cuts on her tongue?
Not that I saw, no.
Did she have any damage to her teeth?
Not that I saw, no.
And you're referencing that she had a cut on the middle of her lip?
I believe it was a scrape, yes.
So she had a scrape on the middle of her lip.
The way you're asking me makes me want to look at my autopsy report. Is that okay?
Of course. It's Exhibit 225.
I have a copy here. Is that all right, or do you want me to wait?
I wasn't aware that this had a copy. So is that a document directed to stand with you?
Yeah, I usually bring it to the stand. I don't have to look at it.
Okay, we'll
So
show
I
you
asked.
Exhibit 225. Is Exhibit 225 a true and accurate copy of your autopsy report? And we can scroll through for you if that's helpful.
This is a photo request. It's not part of my normal autopsy report.
Can you scroll down? I think you identified that there's a photo request on the first page of Exhibit 225.
Yes.
Other than that photo request, is Exhibit 225 a true and accurate copy of your autopsy report?
Yes.
And is there,
I'm sorry, can I look at page 5?
I was going to ask you what page, so we'll take you to page 5.
Thank you. So yes, the very first sentence says there is a 1/8 by 1/8 inch red brown abrasion in the center of the upper lip. So that's a scrape.
Was this scrape a small scrape?
It was 1/8 inch.
Is that small in your opinion?
Whatever you think 1/8 inch is. Lips are quite small, so in relation to the lips, it might be large. In relation to your back, it might be small.
Did you consider this to be a small abrasion or a small scrape?
Sure.
Were the injuries that you noted on Ms. Mullis's face consistent with Ms. Mullis having fallen?
They could be caused by a fall, yes.
Were these injuries more consistent with a fall than with another explanation?
No, they didn't have any sort of pattern to them that would lead me in one direction or another. So they're called blunt force injuries. They're injuries that occur from the impact with an object that has a flat surface. So that could be the ground. That could be something else that simply has a flat surface to it. It's hard for me to know exactly how they occurred, but a fall is absolutely a possibility.
Did you tell investigators during your briefing with them on November 14th of 2018 that Ms. Mullis's facial injuries were perhaps more consistent with a fall?
I don't recall saying more consistent with a fall, but absolutely could be due to a fall.
Your Honor, we have two exhibits that we've put side by side just for comparison purposes, which are Exhibit 570 and Exhibit 621. And I'll just represent that we've made some redactions just for privacy purposes, but otherwise these have not been altered.
What was it?
570 and 621. Are you seeing two images in front of you?
Yes.
All right. Do you recognize one of these photographs to be a photograph that you took during your autopsy?
Yes.
And is that a photograph of the area of Ms. Mullis's chin where some portion of her face has been redacted?
Yes.
And which side of the screen that you're looking at does that the photograph that you took at autopsy appear on?
On my right side of the screen.
Okay.
With the ruler.
And do you see a photograph on the other side of the screen as well?
Yes.
Do you recognize where that photograph is from?
No.
Have you ever seen the photograph on the left side prior to today?
I do not recall having seen this before.
Do both of these photographs that you're seeing on the screen in front of you depict the area of Miss Mullis's chin?
As I said, I've never seen the other one before. It looks like a similar injury to the injury I saw on Miss Mullis, but I can't even say that's her.
Prior to your deposition in 2023, had you ever seen any photographs of Miss Mullis that were taken at Regional Medical Center or Region Medical Center?
I had, yes.
And do you recognize the photograph that appears on the screen in front of you that is not the one you took to be a photograph from that set of photos?
I assumed it was, but as I stated, I don't recall having seen it before.
In your view, does the chin, the appearance of the wound on the chin other than the drying?
The bruising around it appears to be more pronounced, I think, in my autopsy photo. I don't know if there's anything else you're looking for.
Are there any other differences that you know?
It's darker in color. The bruising appears more pronounced, but it maintains its same general shape.
When injuries on a person's body are exposed to air, can that lead to drying?
Yes.
And what does drying impact the appearance of abrasions, for instance, on someone's body?
Yes.
How can drying impact the appearance of abrasions?
Well, this is a good example. It changes the color of the wound, may change the size slightly. It doesn't really change much else. Experience helps you interpret them appropriately.
Well, does the injury to the chin on the photograph that you took at autopsy look more pronounced than the injury to the chin in the other photo?
The dark color from the drying makes it stand out more.
Is the injury to Miss Mullis's chin that's depicted in the photographs, or the photograph that you recognize of the two that are in front of you, is that injury consistent with a fall?
It could have occurred with a fall, yes.
And is there any evidence that the chin injury that's depicted in the photograph that you're looking at was caused by anything other than a fall?
There's no pattern within it that I can tell that tells me what caused it. So it's from the impact of an object with her body, and that object has a flat surface. So it could be the ground, it could be an object as she's in the process of falling the ground when she falls, or another object striking her while she's in another position.
In your testimony at Mr. Mullis's criminal trial, did you tell the jury that this injury to Miss Mullis's chin was consistent with a fall?
I don't recall saying that, but I maintain that today is consistent with a fall. It's also consistent with any other type of blunt force injury.
Did anybody ask you at Miss Mullis's trial whether this injury was consistent with a fall?
I would have to look at the transcript.
And we'll come back to that. And I want to go back to her ears, because that's something that you mentioned earlier. And if you need to see some photographs of her ear to refresh your memory, I can show you that. But in your conversation with the investigators on November 14th of 2018, did you tell those investigators that any bruising around Miss Mullis's ear could also be consistent with her falling?
I don't recall, but independently, Now I say, yes, it could be from a fall. She has earrings in and she had bruising to the backs of her ears and on her earlobes. And that could be from her hitting the ground and the earring causing injury to her ear and the skin around her ear.
Could the bruising that you noted around Ms. Mullis's ear be consistent with bumping her head against some surface as she walked? For instance, hitting her, head on a door jamb as she walked through a door.
Yes.
Could it be consistent with banging her head on, some object hanging from the ceiling as she walked through a space?
If that injured her ear as well, then sure.
I mean, is there any way to distinguish the bruising on her ear from someone's everyday activities?
It has the standard definition of a blunt force injury. I can't tell the nature of the injury, so it could be from sort of activity of daily living.
Did you tell investigators on this call on November 14th of 2018 that Ms. Mullis had a pretty low baseline hemoglobin?
I did say that, yes.
All right, and can having a pretty low baseline hemoglobin be something that can lead to anemia?
Well, that's what anemia is.
You're identifying that Ms. Mullis had anemia?
Yes, from the medical record, she was anemic.
Can anemia lead to dizziness?
Yes.
Can it lead to weakness?
Yes.
Can it lead to people falling?
Yes.
Ms. Thompson, is this a good spot for?
It is. It is, Your Honor.
Let's go ahead and take 15 minutes. We'll plan on resuming at about 30 or just before. Court's in recess till then.
right, guys, I am going to end this. My fingers are hurting. Dang, my fingers are hurting. All right, guys, I will see you guys later. I think it's enough of this. Okay. I'm trying to figure out, should I do the meeting now? Mimi, I know some people are not off from work. I know some folks are not off. We'll do it about 5:30. Does that sound? Well, Dallas will be off. Let's do it in the next at 4:30. Let's do it at 4:30. Mod meeting at 4:30. Catch you guys later.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click